Good morning. I forgot to add myself before I clicked over here. Good morning. We are here for another day of this trial. I kind of think that Nate is on the money about today could be the final witness for the prosecution. I think so. I think we're at the end. I think we're going to be seeing the defense start tomorrow. And oh, wow, can't wait. But first, I want to give the room a chance to load real quick while I show you. I kind of put it up. I did. I put it up a little bit. I put up the that malachite ring thing that I made yesterday. I was going to show it to you guys again. Uh, there, look at that. You guys can take a screenshot of it, or you can pause it and read all about all the stuff that malachite rings do. I kind of had to do it. They were talking about it yesterday. So there's some info on it. Let's see. I want to come over here really quick and say hi. And then we'll get going with my little recap. Let's see who started it. Who started the day? Candy did. Hi, Candy. Good to see you. Beanie, good to see you. Linda's here. Yay, Linda. Whew. Francis Thompson is here. Luna Lake. Luna Lake. I hope you're doing better every day. Mwah. Brian, good morning. And that's it. I love our little morning group. It's very easy to get through. Okay, so I put together a little bit of a recap that should get us pretty close to start. I need to make sure that I can see when it starts, because I can't see the screen when I have my thing up to listen. Oh, let me do this. I'll add that, and then we'll do it kind of like that. All right. So yesterday was day 24. I cannot believe we've been doing this for 24 days. Now going into 25 days. Wow. So Judge Boyce did say that today will be a short day. There's one more witness for prosecution, and then most likely, this is according to Nate, most likely the state will rest. This will be 67 witnesses in total for the prosecution's case. Tomorrow will be the start of defense's case. If something happens and they end up running over and they got to finish witnesses for prosecution, you never know. You don't know if stuff is going to be, you can't plan. You can't plan on any trial ever. Good morning, Maria. Let's see. Witnesses yesterday were retired FBI agent Rick Wright, Rexburg detective Ray Hermosillo, and AG investigator Nicholas Edwards. Prior crossed agent Rick White, that's what he started the day off, because they ended on the day before with direct ending, and then started with prior yesterday morning. He asked a lot of questions about Alex's phone activity from his device the night Tammy died. Alex's device was at the church that night, and for about an hour, there was no data coming in. Then they picked up Alex. Then what they picked up after that was what Alex was doing. He was driving south to Idaho Falls. Then he was it His device was spotted at the Hilton Garden Inn in Idaho Falls. Okay, so what do y'all think about that? What do you think happened in that hour? We talked a little bit about this yesterday, and y'all know I've said it, but I'm going to put some questions to you. Did he get out and walk around? Nate asked all these questions. Did he get out and walk around or walk to the house? Did he sit in the car and turn off his phone? And why, after, did he go to a hotel instead of going to his home in Rexburg? These are the questions Nate asked, and I thought they were awesome. But you remember I was saying that I totally think that he left the phone in the car turned off. Because my question was, I kept asking this, if you leave a phone and just set it down, does it continue to put out data? It depends, in my opinion, it depends on the phone, and it depends on what apps are on it. If you have apps running, then those apps, if they are continuously able to use the data, then that would happen. If not, if you turn all the apps off and they don't get to use the data, if you sit the phone down, I do believe it's idle and there's no data coming in. But I think that he either turned it off and had it with him and turned it back on when he got back to the car after he'd walked 2.6 miles, or he turned it off, left it in the car, went up there, did the deed. Sorry, I think he was there. I don't think it was Garth. I don't think it was Chad by himself. I think he had help. And I think that Chad or Alex walked his happy butt up to that house and helped out. But my biggest question was, what happens with the phone? We never really got a clear answer with that. I'm looking at the chat and kind of seeing what y'all are saying as I'm asking these things. Maria says, just got here, about to click that button. Yay! Thank you for clicking the button. Will the state, most likely I'll get to the questions, but yes, the state will probably have a rebuttal. Absolutely. They probably already have it all lined up with their rebuttal witnesses ready to go. Maria says, I admit I don't understand the significance of the hotel. And I think a lot don't. Why was he in a hotel? It makes no sense. If his house is in Rexburg and it's close by, it makes no sense to stay in a hotel. Good morning, room. Good morning, Toby. Okay, so after they got done with Mr. Wright, they finished his testimony. Detective Hermosillo was up. He was given the job of listening to all of the calls between Lori and Chad when she was in jail and he was out. 3 months worth of jailhouse calls. There were 10 to 15 calls a day between the two of them. Pardon me. They were fully aware that those calls were being recorded. There is no evidence that they ever said anything damning, but there is one call with a lot of code words. This is the call where Chad says he's able to text Alex, who was deceased. And my facial expression, I think I may have had a few during that. Uh-oh, my dog is barking. Hold on. Oh, back to it. Sorry. Where did I leave off? Okay, so 10 to 15 calls a day between the two of them. They were fully aware. They're blah, blah, blah. There was one call with code words. This is the call where Chad says he's able to text. Like I said, this call had me in my facial expressions. Lori didn't even question him about this grandiose ability. I was thinking that we could actually play that call. I have it set. We can kind of listen to it a little bit later on, maybe during the first break, and I don't remember how long the call is, but I was kind of thinking we could go back and listen to it and pick it apart. Maybe I'll stop it and we can talk during it or something. But that's about all. There was Investigator Edwards. Uh, I didn't get that far as my notes are on that one, because I can't remember. I'm tired. I forget what his testimony was, because actually no, let me do this here. I can remind myself really quick. Yep, I forgot. We have the where is it? Yeah, there we go. Okay, so Edwards was all about, trying to go back to trying to get to the beginning of where. So okay, so he was on a long time. He was the majority of the rest of the day. He's the one who, here it is, Edwards question. He was asked about the rifles and stuff like that. Like part of the thing was it was all about the rifle, and some things that were said about Alex and his not being very good at shooting, it seems, but there's probably something to it. I've always felt like with him shooting and stuff and him and missing twice, that was for a reason. I'm still not 100% sure what the reason is, but Edwards, this was all about the text messages and stuff, and then I think he spoke also about the text, eager to see who's soon. Oh yeah, all of these text messages continues a time. And there was a timeline that he was dealing with and all the stuff, but that was a whole lot. I never got that far in taking notes for my recap. But I was kind of thinking that, during the lunchtime, we could replay some of Edwards from yesterday. That way we get this, we get that in again. But we should start seeing them hopefully soon. Let me get back to the chat and see what y'all are saying. It was a very small update for me this morning. Wednesday, what is this, Thursday? Thursdays are usually my day where I'm exhausted by the time the week happens, gets this far. And my brain was like, yeah, okay, girl, you done. Let me turn off this light. There we go. I look less pale there, that way. Helps to put me in the dark. So, let's see what y'all are saying. Francis, got it. Yes, yes, we very much hope that Luna is doing better every day, better and better. Back surgery is a lot to recover from. It takes forever. See, make sure I didn't miss anybody. I went back a little too far. Hey, Bridget, good to see you. So Toby says, we're never going to get a clear answer about anything to do with Alex. It's true he had a brain injury when young. I don't know. I wish that, I think it was planned this way, really, to make it so much about or him being in charge of it, and like he knew he was the fall guy. He knew it. He said it to Zuzu, Zuli, Zuluma, whatever anybody wants to call her. But he was, yeah. There's just not enough to know. Everything is speculation and everything is he said, she said anyway. So sad. But I think that between he and Chad and whatever Lori's part was also. I mean, just being a part of it and knowing that this stuff is happening and all this stuff is enough for me to feel okay with a full-on conviction. Candy says, my little brother who was 21 came by the other day and our dogs went bonkers with the barking. Oh my goodness. Yes. It's this time of day when, the kids are all going on their way to school. You got people walking their dogs in the morning because it's daylight here now early. And so they like to, our dog sits, there's a chair upstairs and he sits in the chair and he watches and looks out the window and watches everything walk by, fly by. We get a lot of turkeys here. We get a turkey pack. I don't know what you call them, a flock. That's it, a flock. I call them a pack because they look like a gang of turkeys. They come every year, pass through, and the dogs bark at them every time. Toby says, I've heard that call 3 times now and wish there was a written transcript. They seem oblivious that 4 people have been murdered and 2 buried at Chad's house. Yeah, like it was just another day, and not just another day in their 10 to 15 phone calls. Yeah, la-di-da. Oh, we don't know if Alex's eyesight was on good or if he had any real sniper training. Yeah, Nate did speak a little bit about that. I want to go back and listen to him later on and see what he had to say about the whole rifle thing. And he had a thing. I never got that far in listening to him. But I think there's something to it. I have a feeling that it's something about some pin that if it's loose, it causes it to misfire or do something funky. I remember that being said a little bit in that testimony, but Edward's testimony was long. Jane, hi Jane, good to see you. We got Hart.
Thank you. Good morning. Our jurors are lined up, so we'll go ahead and have them brought in. If everybody would remain standing, please.
So I'll keep going with the kitchen up. Okay, so we are caught up. I caught up on that. Pazuzu.
All right, wait.
Oh. All rise. Steve is not here yet.
It's all for the counter for you.
Thank you. Please be seated. All right. Good morning, everyone. We're on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're continuing with evidence on the state's case in chief. The court notes the jurors have all returned, and I've received the juror affirmation from each one of the jurors that they've followed the court's admonishing instruction as we wrote for the day yesterday. So thank you again to each of you for following that instruction. At this time, then, I believe the state is prepared to call its next witness. Is the state ready to proceed with a witness?
Yes, Your Honor.
Who will that be?
Doug Hart.
Very well. You can call your witness, Ms. Blake.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I do.
That's just right in here.
All right, before we get started with direct examination, then would I refer to you as Agent Hart?
That's fine, Judge.
Agent Hart, with the court's exclusionary order here, I'm going to ask, because this case has been live streamed as well as open to the public, have you watched any of the trial testimony that's taken place?
No, I have not.
Have you talked to anyone else about testimony they've provided?
No.
All right, thank you. Ms. Blake, you can inquire on your direct.
Thank you. Agent Hart, can you remind the jurors where you currently work?
At the present time, I'm the chief deputy for the Canyon County Sheriff's Office.
And where did you work before that?
Prior to that, I was an FBI agent for 27 years.
And when you were with the FBI, did you become involved in a case involving some missing children named Tylee Ryan and JJ Vallow?
Yes, I did.
Did you personally assist in that case or work on that case?
Yes, I've worked on the case since its inception in November of 2018. Or 19, excuse me.
And can you explain why the FBI came to be involved in that particular case?
Yes, it's a very common occurrence for the FBI to be asked to assist in cases involving missing children. Of course, when those cases come to us at the onset of the case, we don't know what has happened. There could be elements of those cases.
Judge, I'm going to object at this point. This has become a narrative.
Overruled.
There could be elements of those cases that would, at a future date, indicate a federal prosecution. And so we're brought in early to assist our city and county partners, and that assistance continues through the entirety of the investigation.
Prior to being involved in this case, had you worked on cases involving missing children?
Several.
With regard to this case, did the FBI follow up on leads?
Yes, there were a tremendous number of tips and leads that were received during the course of this investigation. Those leads that involved information out of the state of Idaho were primarily handled by the FBI, and those tips and leads that were within the state were generally handled by the Rexburg Police Department or the Fremont County Sheriff's Office.
In this case, let me back up. Is it common in a case with missing children to look at the parents?
You look everywhere. You cannot have blinders on as a case develops. You have to follow the evidence and follow all of the investigative measures and leads that exist. And that's the process. Sometimes parents are involved, but you don't automatically look to any one individual at the onset of a case.
And is that in fact how the investigation proceeded in this case?
Yes.
Are you aware if other specialists or other branches, I may be using the wrong term, other areas of expertise within the FBI became involved in this investigation?
Absolutely, several did. The FBI possesses individuals and units that have particular skill sets that oftentimes can't be replicated due to resources by a city police department or a county sheriff's office. And so in this case, we had forensic accountants, we had electronic cellular telephone specialists, we had the FBI lab, we had our evidence response team, we had analysts, so on and so forth. Each of those individuals or units have a particular expertise and skill set that were brought to bear in this case as our needs dictated.
And Your Honor, I'm going to ask if I can be handed State's Exhibit 170.
Very well.
Agent Hart, as part of your work with the FBI, did you work on reservations?
I did. I have spent approximately 14 years of my career, either full-time or part-time on various different Indian reservations.
And with that, did you deal with any kind of burial sites?
Yes, when you're assigned to an Indian reservation, there are specific trainings that you go through in preparation for the types of cases that you might see. One of those trainings is the identification of clandestine grave sites, as well as how to process and exhume clandestine graves.
We talked about you being involved in the search for some missing children. Were you also involved in recovering their remains?
I was present on June 9th and June 10th of 2020 for the search warrant that was executed at Guy Daybell's property, where we located the remains of JJ and Tylee.
Your Honor, I'm going to ask to be allowed to publish States Exhibit 170C, D, E, and H,
All right, can
one
you,
at a time.
with Exhibit 170, what does that entail in total?
The Exhibit 170 runs from 170A to 170U. And then there are some additional portions of it. The packet or the portion that I'm focusing on deal with images taken from the body recovery site.
Okay, and that's an admitted exhibit, correct?
It is
Okay. Thank you for the clarification there. So you've requested 170 C, D, and H.
E and H.
Okay, those may be published.
Thank you. And Agent Hart, I believe there may be a pointer up there if it's helpful with your testimony.
Got it.
And for the record, I'm currently publishing C. Agent Hart, can you tell us if there's anything within this image that you noticed when you were on scene?
Yes, I think there's some better photographs, but this is a photograph of the location of JJ's burial, which you can see kind of in this area.
And I'll move now to States Exhibit 170D. And when you said there were some photos showing it a little bit better, is this one of those?
Yes, this demonstrates what we look for when we're searching for a clandestine grave site. One of the telltale signs is a change in the plant growth that's fairly distinctive. So you can see consistency all around, but in this rectangular area here, you have a different color of plants, as well as just some lack of growth. And so as you look, you can see a fairly distinctive area here. And this is what I observed as we were doing our initial survey of the property.
And now publishing 170E. Does that show anything additional?
It's just a closer demonstration of the a pretty specific line, and as we felt in the dirt, you could actually feel a seam where the sod had been taken up. And again, just an indication that that may be an area where digging has taken place, which proved to be true.
And when you talk about you can actually feel, do you mean with your hand?
Yes.
and now publishing 170H. And do you recall what is in this image?
Yes, as we were walking the property, we have probing sticks, and that's a way to push a rod into the earth. On that spot where we've shown the different growth, I couldn't penetrate that area with a probing rod. And as we took up the first layer of sod, we found a board and rocks, which is what I was hitting with the rod as I was attempting to probe that site.
And again, that's something that you had done previously in your career?
Yes, I've had specific training for that. And prior to that time, I had personally been involved in search warrants with the exhumation of burial sites.
And once those things were removed, what was found underneath those?
JJ's body.
After the recovery of the children's bodies, at any point, did you attempt to speak with the Daybell children?
Yes, myself and another agent went over to their residence, which is kitty corner to the Daybell property, on the evening of June 9th, and spoke with them at length about what was taking place.
Was it your understanding initially that they would agree to speak with you?
That's the request that I made to them. We explained that we had some things that we wanted to tell them and talk with them about, and asked if they would sit down and meet with us.
At some point, did they decline to meet with you?
Initially, they agreed to meet with us. And then the following day declined to keep that appointment after speaking with Chad Daybell.
Judge, I'm going to object at this point. There's no foundation to suggest that information. I'm going to move to strike.
It's overruled.
Agent Hart, as part of the investigation, and I think we've talked about this before, but did you review some iCloud data?
I spent well over 100 hours reviewing iCloud data, yes.
Do you recall what iCloud accounts those were?
There are two. There's one entitled Lori for Style at iCloud.com, and the second is called Lolly Time at iCloud.com.
And who were those accounts ultimately associated with?
Both of those accounts were registered to or subscribed to Lori Vallow.
And in going through those, was that a significant amount of information?
It's a tremendous amount of information, tens of thousands of text messages, multimedia messages, voicemails, thousands upon thousands of photographs, videos, emails, everything that you would find on a modern smartphone. The iCloud is simply a cloud storage device for all of that content.
And in preparation for your testimony today, did you prepare an exhibit?
Yes,
Do you believe that exhibit would assist you in testifying today?
it would.
Do you believe the exhibit would assist the jurors in understanding your testimony?
I do.
Your Honor, I'm going to hand to the court what's been marked as Exhibit 183B. I will note there are printouts of a PowerPoint. The PowerPoint or the exhibit itself is actually contained within a jump drive.
All right.
And with the printout, I do have a courtesy copy for Your Honor as well as counsel, and one for the court.
Thank you.
And if I may have the witness handed a copy of 183B, the printout.
And Judge, could we have a sidebar, please?
Yes.
Already a sidebar. So they're probably going to try to, he's going to try to see wait, well, let me look back at what Linda said. What was this thing they're trying to get in? So Hart, my tweet deck is not updating regularly. It's very tweets are very slow today. We're noticing. I don't know if it's a net thing from the courthouse. I don't know, but if it's a Thursday thing and Nate's tired, but they're coming in not as fast as usual. See, Hart spent tens of thousands of text. Oh, so here we're gonna go over. So there's tens of thousands of text messages, multimedia messages, voicemails, thousands upon thousands of photographs, videos, emails, everything you would find on a modern smartphone. Oh, woohoo. I like that. I like a lot of texts. I like 7,000 to 10,000 pages of text type of thing. Oh. So then here it is. This is what I'm looking for. It explains they wanted to talk with them about some things and ask the kids.
All right, thank you, counsel. Based on that sidebar, there's a evidentiary ruling the court is going to need to take up on the record, but outside the presence of the jurors. I think this will be a quick argument in lieu of a break here. If we could just have the jurors line up in the hall, please. And we'll go on the record with the objection. Once the objection's resolved, the jurors will come right back in.
All right, wait.
All right, thank you. Please be seated. We're outside in the courtroom, the jurors have been excused for hearing on an evidentiary objection. The state's proposed exhibit 183B. Defense has an objection at this point, and I found it's proper to take it up outside the jurors' presence so that any reference to what may not come in would not be heard by them. So, Ms. Blake, perhaps if you give additional foundation of what the proposed exhibit is, and then I'll hear any objection from the defense.
Yes, Your Honor. The exhibit is content from the iCloud accounts associated with Lori Vallow, that Lori for Styles and Reali-Tea. Both of those are stipulated to exhibits, meaning the entire content has been stipulated to come in. This particular proposed exhibit is excerpts directly from those accounts, I believe mainly from the Reali-Tea account. This was turned over to defense counsel at the end of January as a proposed exhibit. There was a few modifications made and the modified version was provided to counsel. However, the modifications made included removing 3 slides in their entirety. There were no other additions or changes made at all to the exhibit. So given that, that's just what the exhibit is.
All right, thank you, Ms. Blake. Mr. Pryor, is there an objection from the defense?
Judge, the objection is not the admission of the exhibit. The objection is that counsel throughout this trial has had a repeated course of action of providing me summaries either late the night before the testimony is to incur or the morning of or late in the evening on, again, the day before. I'm not objecting to the admission of the emails from Reali-Tea. In fact, that was a stipulation of the parties that those be admitted. What I'm asking for is an opportunity to ensure the one Miss Blake is representing doesn't contain anything outside of what was stipulated to. And the fact that I got an email, I believe it was last night or the night before, that there were modifications made to this. I want to ensure that those modifications are as they were represented, and I ought to be afforded that opportunity.
All right, Ms. Blake, to be clear then, the modifications were taking things out of the proposed exhibit, not adding things in. Is that correct?
Correct. None of the remaining slides have been modified or altered in any manner from what was turned over in January. The only modifications were the removal of 3 slides.
Okay, well, considered the objection here then, first, expressly was indicated there's not an objection to the admission of the exhibit. So with that and it being offered, the court will admit exhibit 183B. In terms of the timing, while I understand it's certainly difficult in the middle of trial to be dealing with any modifications because this involved the taking out of some information, not adding it in, I think the court could presume that defense counsel has had an opportunity to review that. So I'll have it now that it's admitted. It may be published. However, if during the course of publishing you see something that doesn't seem to comport with your understanding of the exhibit, Mr. Pryor, you are allowed to make an objection, and I would ask the state be ready to stop publishing on quick notice if an objection comes up.
The state has no problem with that, Your Honor.
Okay, thank you. And I'll note also then this would be a summary exhibit under Rule 1006. Is that how the state's offering it?
Yes, Your Honor.
Okay, well, the exhibit's admitted then, and with the objection resolved, we'll have the jurors return for additional evidence.
Yes, Your Honor. All right, please. Resolved, President counted for, Your Honor.
Thank you. Please be seated. All right, we're back on the record after resolving that evidentiary issue. The court notes that Exhibit 183B has been admitted, and you can continue with direct, Ms. Blake.
Thank you, Your Honor. The state would request to publish 183B.
You may publish.
I believe the court has the original jump drive if you'd like me to publish from that.
All right, we'll get that submitted.
Agent Hart, does this appear to in fact be the exhibit created by you?
It is.
And Your Honor, I'm going to pause here to allow the jurors to read.
Very well.
And Agent Hart, can you indicate who these messages were being sent from and who these messages were being sent between?
These are messages between Lori Vallow and her brother, Alex Cox.
And can you read the date of these messages into the record?
These three messages are from March 20th of 2019.
When we look at these particular messages, what about them caught your attention?
Alex Cox was a figure during the course of our investigation, and what caught my attention about this particular interaction between Lori Vallow and Alex Cox is in line 1837 that Lori Vallow had to check everything with her quote source to make sure she had her information correct, but that it was really good.
Did this indicate to you that Lori herself didn't have this information?
Yes, that's why I think it's significant.
And did you also see in here that Lori was then going to pass that information on to Alex?
Yes,
Did you learn through the investigation who Lori's source was?
Foundation.
Sustained.
Through the investigation, did you see messages from Lori to Chad quite frequently?
very frequently.
In those messages, was she oftentimes requesting information?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, would you indicate the date these were sent into the record?
Yes. These four text messages were sent on July 18th of 2019.
What had happened 7 days prior to these messages?
Lori Vallow's husband, Charles Vallow, had been shot and killed.
Through your investigation, did you learn who Hillary was a reference to?
Yes.
And who was that?
Tylee.
And there's also a name in here, Raphael. Did you learn who Raphael referred to?
Raphael is a name, another name used by Chad Daybell between he and Lori Vallow very frequently throughout the course of their communications.
And also a name, James. Do you know who that referred to?
Yes, that is another name for Chad Daybell as referenced in the James and Elena communications between Lori Vallow and Chad Daybell.
And did you learn who Amy was in reference to?
I did not, could not find out specifically who Amy was.
What about this series of messages stood out to you?
There were three very critical components to these messages.
Can we go through them one by one, please?
Yes.
What was the first one?
The first is line 2667. This is a text that is initiated by Chad Daybell to Lori Vallow, indicating that he has been instructed to focus his efforts on Tylee Ryan.
And what was the second thing that stood out to you?
The second thing is present in the following two lines, 2665 and 2660. Lori Vallow makes a reference to Chad Daybell or a request to find out her, meaning Tylee Ryan's percentage, as well as JJ's percentage. That word is referring to the death percentage for Tylee Ryan and JJ.
Judge, I'm going to object. Calls for speculation. Move to strike.
Overruled.
In fact, in subsequent texts, the
Judge,
exact,
I'm going to object at this point. Non-responsive. There hasn't been a question.
Sustained.
Agent Hart, you were explaining why those lines stood out to you. Could you please continue your explanation?
the words death percentage are used in subsequent texts. This series of text messages is the first in a series of texts that will take place over the next 3 weeks between Lori Vallow and Chad Daybell. In those text messages, in varying degrees of detail, they refer to the death percentages of Tylee, JJ, and Tammy. Those text messages over that course of 3 weeks.
Judge, I'm going to object at this point. It's again becoming a narrative.
Sustained.
And what course of time or what period of time did those messages cover?
Approximately 3 weeks.
And when we look at that line 2660, there is reference to specific percentages, it appears.
Yes.
Could you talk about that a little bit?
Again, this is a message from Chad Daybell to Lori Vallow wherein he is indicating his death percentages for Tylee at 0.13 and for JJ at 99.99, which follows with a reference that Raphael or Chad Daybell had visited JJ and told JJ to follow Amy into the light, which is a common reference for death.
In this particular message, there's also a reference to turning up the pain to 10. Who said that again?
Chad Daybell.
And also a reference to placing a spiritual virus in her. Who said that?
Chad Daybell.
And then in that last sentence, did anything about that stand out to you?
Well, line 2660 is a specific conversation regarding the deaths of Lori's children.
Judge, I'm going to object. That's calling for speculation and conclusion, and I'm going to move to strike.
I'll sustain the objection and strike the response.
Based on your investigation, your experience and review of these messages, what did you believe line 2660 to be referencing?
It's referencing their death percentages,
And who are they?
Tylee and JJ.
And what is Lori's response to that, to the talk of death percentages of her children?
That it's sweet and she misses Chad Daybell desperately.
Was this the first time in these messages that you had seen reference to these death percentages that you can recall?
Yes, this is the first message, and there are several that follow in the next 3 weeks, and then later on, there are additional similar conversations regarding Tammy.
Were there additional messages on July 18th of 2019?
Yes, this conversation continues for the next couple of slides.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, you indicated these are a continuation from the messages on the previous slide. Is that correct?
Yes.
What about these particular messages stood out to you?
Primarily lines 26, 22, 2608, and 2607.
Through the investigation, did you become familiar with what has been referred to as the James and Elena story?
Yes.
Did you become familiar with some of the texts that appeared to be a reference or continuation of that story as well?
Yes.
And do you know were you familiar with the term storm?
I am.
And did you know what that was in reference to?
Yes.
And what was that?
That's Chad Daybell's penis.
And Chad's texting to Lori to grab him by his storm and he'll
Judge, I'm
follow
going to
her
object
anywhere?
at this point. It's somewhat leading. And I think
Sustain on leading.
What else about that series of 3 messages caught your attention?
Well, throughout Chad Daybell and Lori Vallow's relationship, Lori is pushing Chad Daybell. And so I included these to show Lori Vallow questioning. Chad Daybell remarks that he'll follow her to the end of the universe. And her response is when? When might that be? Chad's response is in reference to a planned trip that he would take the following week, July 24th through July 26th of 2019, to be together with Lori Vallow. That's the reference to Wednesday evening to Friday. But we see Lori Vallow pushing Chad Daybell as it relates to their relationship.
So it would be Chad and Lori were going to be together physically or at the same time.
Yes, Chad Daybell traveled to be with Lori Vallow for a period of 2.5 days.
And again, during this time, was Tammy Daybell still alive?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, I believe you indicated these are a continuation as well from the previous 2 slides.
They are.
What was it about these messages that caught your attention?
Primarily, there was 2 things.
And can we go through them one by one?
Sure.
What was the first thing?
The first is again, we see Lori Vallow manipulating Chad Daybell. In the prior slide, Chad Daybell had indicated that they would have this time together Wednesday through Friday. And Lori Vallow's response to that is, then what? And she then says, back to crying and saying goodbye, back to the box, as a reference to being trapped with their inability to be together.
And at this point in time, Charles Vallow has been killed,
This is 1 week following his death.
but Tammy's still alive.
Correct.
And what was the second thing?
The second thing is line 2603, which is Chad Daybell's response to her. And he references that extreme changes are coming for him, and he welcomes those changes.
And do you recall from previous testimony references Chad also made about feeling trapped?
Judge, I'm gonna object. It's leading.
Yes,
And do you recall approximately, or do you recall what those statements were, what that was in reference to?
yes, that conversation took place at the conclusion of this trip that they're talking about. So that would have been on July 26th of 2019, where Chad Daybell references the Harry Potter stories and feeling trapped, having to live under a stairwell, and he gets to escape occasionally to have adventures with his goddess lover.
And when you look at that line 2603, there's a reference to extreme changes. Did that catch your attention?
It did.
What did you, through your investigation and experience, what did you believe that to be in reference to?
Judge, calling for speculation. Objection.
Overruled.
Well, within 3 months of this date, Tylee, JJ, and Tammy are all dead.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged into the record?
Yes, this is July 20th of 2019.
And who are these messages between?
Lori Vallow and Chad Daybell.
There's an individual reference named Blake. Did you learn who that was?
Blake is Melanie Boudreau's son.
Do you know his approximate age?
3 to 4 years old at the time of this message.
What about these messages caught your attention?
There were 2 things primarily that caught my attention in this series of communications.
What was the first one?
The first is, again, Lori Vallow is petitioning Chad Daybell to find out Blake's percentage. So repeatedly, we see Lori Vallow asking Chad Daybell to provide that information. Chad Daybell is the source of the death percentages.
What was the second thing?
The second thing is that this is a conversation about a 3 or 4-year-old child. And in line 2481, Chad Daybell writes that he decreased that child's pain tolerance to 1% and greatly increased his pain.
And do you recall in one of the previous slides in reference to Tylee Ryan, Chad talking about turning up or causing her pain?
Yes.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged into the record?
July 23rd of 2019.
And who were these messages between?
Lori Vallow and Chad Daybell.
What about these messages caught your attention?
Again, 2 things primarily caught my attention.
And what was the first thing?
The first is if we look at the time of these messages, there's an 11-hour gap between line 2276 and 2244. In line 2276, Lori Vallow petitions Chad Daybell to check JJ. In the subsequent line, 11 hours later, she's asking Chad Daybell to check Tylee to see if Tylee has been, quote, switched. And so these messages are 5 days after the initial first message that I ever located regarding death percentages. And so this is now the second time that I could find in the review of the iCloud where Lori Vallow is asking Chad Daybell specifically to check on JJ and then to check on Tylee. So that's the first thing that stood out to me.
And Charles Vallow had been killed not long before these messages.
12 days prior.
What was the second thing that stood out to you?
The second thing that stood out to me is in line 2241, which is Chad Daybell's response to her. And he replies that, yes, Tylee has been switched. And he says, let me know when you can talk and I will explain it. So Chad Daybell is the one who will explain.
Judge,
to Lori
I'm going to
Vallow.
object at this point. Speculation.
And what was the last part of that answer?
Lori Vallow is making inquiries to Chad Daybell, and Chad Daybell tells her, I will explain it.
Prior to Charles being killed, are you aware if he was deemed to have been possessed?
He was.
And ultimately, he was killed.
He was.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you read the date of these messages into the record?
Yes, July 26th of 2019.
So this is just 3 days after those last messages we looked at.
Correct.
What about these messages caught your attention?
That the pattern of Lori Vallow asking Chad Daybell to check is continuing. So on line 2119, Lori Vallow writes, "Need you to check JJ," and references his behavior, which was a departure from what was normal for him.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you read into the record the date these messages were exchanged?
These messages were also, as with the previous slide, on July 26th, 2019.
What about these particular messages stood out to you?
Well, in response to the previous slide's request by Lori Vallow to Chad Daybell to check JJ, Chad Daybell replies that essentially JJ is still his true self, but he indicates whoever told Lori Vallow that JJ was calm and watching movies had been lying. So Chad Daybell answers Lori Vallow's inquiry regarding checking JJ.
And looking to that next message, are you aware who Brighton is?
Yes,
And who is that?
Brighton is another of Melanie Boudreau's children.
And the name Mel there, do you know who that was referencing?
That's Melanie Boudreau.
Was there anything about that next message that caught your attention?
This next message is somewhat vague, but we see a reference to a big plan, which is a word that we see repeatedly in conversations between Lori Vallow and Chad Daybell referencing their plans.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you read the date of these messages into the record?
Yes, these 4 messages were exchanged on July 29th of 2019.
Who were the messages being exchanged between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
At this particular time in the investigation, Lori Vallow, Melanie Boudreau, and their children, as well as Alex Cox, had decided to take a trip to the California coast. And so these messages were sent to Lori Vallow as they were driving in the car, as Lori Vallow, Melanie Boudreau, Alex Cox, and the children were driving to California. And so Chad Daybell makes an offer to Lori Vallow to cause pain to the 2, quote, threes that she was riding with.
And looking at that, at the line 1872, did any of that catch your attention?
Of course. In line 1877, the 2 threes are referencing 2 of the children that are in the car with them. And in line 1872, Chad Daybell indicates that he would at least give them a reason to scream, indicating a supposed ability to cause physical pain to those children.
After offering to cause physical pain to the children, what were the next things he said?
He told Lori that he loved, cherished, treasured, and adored her. The wonderful memories just keep coming back. She was mesmerizing, and that Raphael, which is the name for Chad Daybell, is one lucky guy.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, would you read the date of these messages into the record?
These messages were exchanged on July 30th of 2019.
And who are these messages between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
There were 3 very critical components of these messages.
Can we start with the first one?
Yes.
And what was that?
The first one is in line 1781. This is a text initiated by Chad Daybell to Lori Vallow. And you can see that Chad said he had the inspiration to go back to my original death percentages. So this is the first time that we see the full phrase of death percentage, and it is attributable to Chad Daybell by the use of the word my. And then he indicates that these death percentages helped him track Charles, which is a reference to Charles Vallow. Ned is the name of the demonic entity that was alleged to be possessing Charles Vallow. And then he indicates that Tammy is very close. Her death percentage has fallen steadily, and concludes with, "It is encouraging!" exclamation point.
Do you also see the reference in there to Hiplos or Iplos?
Yes,
Do you know who that's in reference to?
that's the name of a demonic entity that was supposed to have been inside of Tammy Daybell.
And you said Tammy
Um,
on Hiplos.
Yes. So it says Tammy is very close. Her percentage, meaning Tammy's percentage, has fallen steadily since Hiplos left. So that entity is now out of her.
Do you recall if Hiplos was an entity that was indicated to be associated with Charles Vallow?
Judge, I'm going to object. That's leading.
Sustained.
Do you know who else Hiplos may have been associated with?
There was another reference to that using that same demonic entity name with Charles Vallow.
What was the second thing that stood out to you?
The second thing that stood out is this reference to Chad Daybell's death percentages that helped track Charles Vallow. Charles Vallow didn't have a heart attack or pass away in his sleep.
Judge, I'm going to object. It's narrative.
Overruled.
He was shot and killed. And so these death percentages by Chad Daybell are not simply a reference to natural deaths.
And what was the third thing?
Well, the third thing is in lines 1779 and 1778. Lori's response to Chad is to inquire, what is the percentage now? Meaning, what is Tammy Daybell's death percentage? And then she follows that up with yet another inquiry. This would be now the third inquiry about JJ's death percentage. Chad Daybell responds, Tammy is at 3, JJ is at 2.
And based on your review and your investigation, in relation to death percentages, what was the indication the lower the number got?
Well, it's not consistent. So you have references where the lower the number, the closer to death they are. And then you have references where the higher the number, the closer they are. So in the previous communication, you saw Chad Daybell indicate that JJ was at 99.99. And he instructed JJ to follow Amy into the light. In this occasion, we flipped and they're at the opposite end of the spectrum, saying that Tammy is at 3 and now JJ is at 2 versus the prior message. So there's a lack of consistency, but the higher the number in one case, the lower the number in another.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were sent into the record?
Yes, July 30th, 2019. These are a continuation from the previous slide.
And what about these messages stood out to you?
Well, first, Lori Vallow's response back to Chad Daybell after receiving his answer that I believe it was Tammy was at a 3 and JJ was at a 2. She replies 2 and 3%, not 0. So we see Lori Vallow pushing 0, meaning the time has come for those individuals to die.
Judge, objection calls for speculation. I'm going to move to strike, Judge.
Well, the objection's not timely. I'll overrule it at this point, but Ms. Blake, I am concerned if the witness is making his own interpretations of these messages, not based on the investigation. So if you could direct the examination that way, that'll help with the objections.
And in coming to that conclusion, was that based on your experience and your review of the information?
Yes.
What else stood out about this particular message?
Line 1776, where Chad Daybell says, "I will explain when we talk," indicating he is the source of what's happening.
Was that consistent with your review of these messages?
Yes, we see that exact phrase multiple times. "I will explain."
Anything else about this particular series that stood out to you?
Well, lastly, again, we see how Lori Vallow is attempting to manipulate Chad Daybell. She concludes this conversation with, "Okay, still feeling hot for you."
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these were being sent into the record?
These two text messages were also on July 30th of 2019.
And who were these messages between?
Chad Daybell and Lori Vallow.
What about these particular messages caught your attention?
Two things.
What was the first one?
The first is a continuation to further explain Chad Daybell's death percentages. In the second sentence, he references this chart that checks what percentage mortals are still in their body, and then indicates that it worked for his friend's wife who died. And so we see just a further explanation of death percentages, and that this is talking about physical, real death, not spiritual death or some other kind of death.
Was that chart that was referenced, was a copy of it ever located?
No, we could never find the actual chart. I can't account for where it might be.
And what was the second thing that stood out to you?
Well, there are two more. The first is that he references Tammy Daybell, his wife, that she said she felt lightheaded as if her body and spirit weren't connected.
And then what was the third thing?
The third thing is in line 1773, where Chad Daybell indicates he would update the list and figure out Brandon, Adam, and others. The reference to Brandon is Brandon Boudreau, and on October 2nd of 2019.
Judge, I'm going to object at this point. This is definitely becoming a narrative.
Sustained.
Who was Brandon referencing?
Brandon Boudreau.
Do you know of something that happened in relation to Brandon Boudreau?
Yes.
What was that?
On October 2nd, 2019, an attempt was made on his life.
Are you aware of an attempt that was made on Tammy Daybell's life?
Judge, I'm going to object. Calls for speculation.
Overruled.
I am.
And when was that?
October 9th, 2019.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these images were sent?
These were both sent on August 7th of 2019.
Were you able to, looking at that first image there, who is that?
That is Chad Daybell.
Can you tell from the photo what type of building he may be in?
Yes, it's the lobby of an LDS, an old LDS church.
And who sent that photo?
So the photo of Chad Daybell was sent by Alex Cox to Lori Vallow with the caption, "Look at the bubbies."
Do you know what Bubbies was a reference to?
That was a word.
Judge objections, calling for speculation, no foundation.
I'll sustain that without additional foundation.
Through your investigation and review of messages, were you able to determine what Bubbies was in reference to?
Yes,
And what was that?
it's just simply a pet name that Lori had for Chad Daybell and Alex Cox or other men in her life.
And could you see the time that that message was sent?
10:48 a.m.
And turning to the next image, who are we seeing in that photo?
That's a photograph of Alex Cox.
Does that appear to be in the same location?
Yes,
And what time was that message sent?
1 minute prior on 10:47 a.m.
Who sent that message?
Chad Daybell,
And who did he send it to?
Lori Vallow.
What was the caption that Chad included?
Two exalted beings.
Was Tammy Daybell still alive on August 7th of 2019?
Yes,
Moving to the next slide, I'm going to pause to allow the jurors to read. Would you please indicate the date these messages were sent into the record?
these messages were exchanged on August 7th of 2019.
Who were the messages exchanged between?
Lori Vallow and Chad Daybell.
And these messages were sent on the same day as those two images?
Correct.
What about these messages stood out to you?
The thing that stood out the most in this text series is in line 1391 in the text from Lori Vallow to Chad Daybell. where she indicates, "We are both so tired of taking care of demons. We are weary. Please ask the Lord to take them!" Exclamation point.
And Lori was sending that request to Chad.
Correct.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were sent into the record?
These messages were exchanged on August 10th of 2019.
And is it fair to say that some of the next slides are going to correspond with the same date?
Yes, it's this slide and the next 5 slides are all a continuous exchange of messages between Lori Vallow and Chad Daybell.
What about this first slide with these messages caught your attention in relation to the investigation?
What first caught my attention is we see now, I believe, the 4th time that Lori Vallow is asking Chad Daybell to check on JJ. And Chad Daybell responds once again that JJ is still JJ.
And at this point, Charles has been dead for almost a month.
Correct.
Through the investigation and your review of the information in this case, did Lori have help with JJ prior to Charles passing?
Absolutely.
And who was helping her with him?
Charles Vallow spent a considerable amount of time and effort in caring for
Judge, I'm going to
JJ.
object at this point. Move to strike. There hasn't been sufficient foundation.
Sustained.
Through the review of iCloud, did you review videos?
Yes,
Did you review other content?
yes,
In that content, were there references to Charles taking care of JJ?
many.
And at the time these percentages are being pursued, Charles is no longer able to assist with JJ.
Correct.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, you'd indicated this is a continuation of the previous slide.
Yes.
And what about these particular messages caught your attention?
Well, primarily line 1170. In the last line of the previous slide, Lori Vallow asks Chad Daybell if JJ is at 0 yet. And we see Chad Daybell's response to that question, yes, he's at 0. He was probably partly through the veil, talking to people both light and dark.
And on the previous slide, in this one, we again see a reference to Blake. Again, who was Blake?
Blake is Melanie Boudreau's child.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, is this again a continuation of the previous two slides?
It is.
Who are these messages being exchanged between?
Lori Vallow and Chad Daybell.
What about these particular messages stood out to you in relation to the investigation?
This particular conversation is some of the most critical evidence that I located within the iCloud. It represents the clearest and most specific reference.
Judge, I'm going to object again. This is speculation.
Overruled.
It represents the clearest and most specific reference to a plan regarding Tylee and JJ. That plan is spearheaded by Chad Daybell.
Judge, I'm going to object at this point. That's a narrative
Also,
and it's argumentative,
it's sustained.
and I'm going to move to strike.
That last part of the comment is stricken.
When you indicate that there's the reference to the plan, who is asking if there's a plan?
Lori Vallow is asking Chad Daybell if there is a, quote, perfectly orchestrated plan to take the children.
What is Chad's response?
Chad's response is that there is a plan being orchestrated for the children.
Where were Tylee and JJ's remains ultimately located?
On Chad Daybell's property.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, is this also a continuation from some of the previous slides?
Yes, it is.
Who are these messages being sent between?
Lori Vallow and Chad Daybell.
What about these particular messages stood out to you in relation to the investigation?
Well, first off is line 1159. In the previous slide, there was a question about a plan and a verification of a plan. Then Lori Vallow asks Chad Daybell, what should I be doing? And in the subsequent line 1158, Chad Daybell provides an answer to her, which concludes with being unencumbered and
There's also a reference in that to telestial issues. Do you know through the investigation what telestial would be referencing?
I do.
What is that?
Issues pertaining to this earthly life.
And in some of the previous messages, Lori was inquiring about the death percentages of Tylee Ryan and JJ Vallow.
That's correct.
What else stood out in relation to these messages?
Line 1155 is very critical. Chad Daybell texts Lori Vallow and indicates that JJ is, quote, getting close. When I was sitting across from him eating bacon, I sensed he was barely attached to his body.
Do you know when the last time JJ Vallow was seen?
I do.
When was that?
September 22nd, 2019.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, again, is this a continuation of some of those previous slides?
Yes, it is. And I believe there's one more that is part of this conversation.
I'm going to move to that slide and pause to allow the jurors to read that one as well. And going back to that previous slide, what about this one caught your attention?
Well, this is just the continuation of the conversation. I think the more important content is on the following slide.
And what about these particular messages stood out to you?
Primarily lines 1117 and 1113. In 1117, Lori Vallow, as we've seen previously, says to Chad Daybell, I can't wait, literally can't wait. I have no patience. I want you now, with 2 fire emojis. And then we see Chad Daybell's response to that, which point.
Based on your investigation, your review of the content of the iCloud, what did you determine the finish line to be?
The finish line was for Chad Daybell and Lori Vallow to live this fantasy life together that they had constructed and referenced in this plan that they're talking about.
Did that include being unencumbered?
Judge, I'm going to object. Calls for speculation.
Overruled.
Unencumbered from her husband and her children and from his wife. Yes.
Your Honor, looking at the time, I don't know if you'd like to do the mid-morning break.
I think this would be a good time for that. Thank you, Ms. Blake. We will take our mid-morning recess. We'll come back on just 10:30 or perhaps shortly before 10:30. Thank you.
All rise, please.
Okay, well, you just experienced me doing something really fast, putting all those up. I had to go do a screenshot, put it into all the stuff, and do a whole lot of stuff quickly. And I should have turned off the camera, but oh well. You got to witness a little bit of autism. That was me going, ooh. So if it ends up all over the network or all over the internet or whatever, that's autism, and you just accept it. Hashtag autism acceptance. Oh, good Lord. I should have put my camera off, but it's okay. It's okay. Yes, that's my stress when I'm doing something fast and I'm focused. That is what that looks like. Oh, well. I was trying to make that bigger for everybody, and I know that Linda was probably putting all that in the text too. So next time we do this and I'm putting stuff up quickly like that, we can forego the texts in the comments, and we'll just go with on the screen. That way you guys aren't overloaded. But it didn't dawn on me until just now that I should have said that. But whatever. Oh well. Oh, sometimes it's still hard to see. And so the text messages go along with it. I know some people are annoyed probably by all the text that we're putting in the chat as far as this is going, but we are trying to make sure that education is going on while we're doing this live. Whew, I am tired now. That dumb plum wore me out. That was like, I don't know, you probably couldn't tell, but half the time I was holding my breath, because that's part of when I'm doing something focused. I'll do a lot of breathing. Oh, whatever. That's almost kind of sort of like a cam slip. So go ahead, make a clip, put it out there. I don't care. I'm sure it will be, but whatever. Now I can breathe. So we are now overloaded by all this. I just put in, what was my final count? My final count of all those texts was 20. That was 20 texts and a picture with the text and stuff. And it was a lot. It was. Wow, holy mackerel. And I'm not going to reread it. So what did you guys do? I could feel prior just trying to really grip onto what was being said and trying to pull it back, like, to do his objections and stuff. He got a couple in, he got a couple sustains, but for the most part, I think that judge allowed that stuff to continue. And Blake really navigated that very well. In my opinion, that was really good, because this stuff right here is key. This is huge. This actually would be interesting to try to take a portion of it later on at a later date and go through it and see if we can kind of see where this is leading, where prosecution is taking this. But I have everything up in front of me, and I've had to stop using all of the five other screens that I have surrounding this one that I'm looking at, because my husband was watching my live and he kept saying, honey, you're looking up at the sky. You need to stop that. And I said, I know, but I have all this stuff laid out, and it looks like the New York Stock Exchange, and it's really easy for me. And he's all like, yeah, but it looks like you're praying to the Lord. Like, okay. So now I've got it all condensed from these here to this one, and it's me switching back and forth. And if I had my sound on, you'd hear a lot of click, 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 click. So it would be a lot. But you got to see it all play out on my face. So I am not going to go back and look at that, because I'm sure that I will not like what I see, and I will be like, oh, good Lord. Oh, good Lord. So I'm just going to leave it and not let it be a thing. It is what it is. So what did you guys glean from that? Oh man, goodness, I wish I had somebody up here with me right now. But trying to do that, I was trying to also listen at the same time. So, trying to keep up with it. Like I said, I've got a little bit of a delay. Then I have to watch for the screenshots that I take it off of my live itself. So then I have to wait for it to pop up and hit the button and then stick it in the thingy and do its magic over there and then upload it to StreamYard and I'm sitting there going, oh God, hurry up. So that's it was a lot. Let me see here. I it's nice to be able to see it on the screen to see what they're looking at. I was going to see if I could actually enlarge and make one of these layouts large. I might do that real quick and let me see if I could do it. I want to see if I could do one of these. Let me see. What if I try? I could do this one and see if I can, because I made that one. Let me see. I'll make sure I don't, I got another one to match, I think, right? Yeah. Oh, that's the bigger one. Okay. So let me see if I can do this. If I try to do this, oh, but it's not on. That's right. I don't think I can make it any bigger. I think that's about all we get. Yeah, it doesn't go up. It doesn't let me go past that. Oh, well. Let's see. No. Oh, good Lord. What the heck did I just do? All right. Never mind. Don't do that. Okay. No, I can't. I was going to say if I could make that one box that has the, if I could make that one box that has the 4 boxes when it's on bigger, but it can't go past. In the thing I use to enlarge all that, it lets me go past the boundary of the size of the thing that I'm making for it's called a layout. So, oh well. Yeah, it'd be neat if this thing had a doohickey where you could like enlarge the screen while you're on it, but it doesn't. That would be too much work for them to create that. So anyhow, you got a little bit of explanation of the back end of me. I feel like I ran a marathon. Oh, so having it both, okay. I just don't want y'all overwhelmed. I know that I see sometimes the comments. Someone will say, "Well, if you want to know if you missed anything, just you could read the entire chat and be caught up." I'm like, okay, did they say that because they were irritated with it, or do they like it? I don't know. So we're just trying to do the best we can and run this the way for y'all. Let me see who. Oh, did I see Lemon Curd? You're here. Hello, my lemon. So let's see. Dana says yes for the jurors. This links Chad as the leader, guiding everyone in what to do and what happens to the kids and others. I wonder how they feel about the fact that I think he's using. I keep putting D&D in the chat, right? Because I don't know if many of you know about the game Dungeons and Dragons, but the way he's explaining all this stuff, it sounds like if you've ever watched anyone play a D&D game, you can probably see it on YouTube. And some people are like terrified to even talk about or even mention the name D&D. It's just, I don't know. I've wanted to get into it myself, but my background of where I came from growing up and stuff and the religiosity that I was in kind of carries over into my current life. And so I kind of like shy away from that stuff. But I don't know. I'm kind of trying to get over that a little bit. The fear of the whole, what I call wee beasties thing. By listening to some paranormal channels on these YouTube streets. And I know that I have 2 two friends of ours from a community we're in, both do paranormal activity stuff. Simply Sophie does it, and Johnny Mac does it. He has a channel for it. It's Fam Paranormal, I think it is. Those two channels. If you're scared to death of that stuff and you don't even want to think about it, and it's all no, we don't want to go there, you know, don't go there. But if you want to check out Simply Sophie, actually, let me see. I'll get it, or yeah, let me get their. I'll get their channels real quick. Hold on, and then you guys can check out Sophie's and Johnny Mac's. I'll see if I can find his other ones. And they do go to they'll go to graveyards and stuff sometimes. Let me get this. Wait, there we go. Simply Sophie. You can go here. This is Sophie channel. She does a lot of different things, and that's hers. And then I think Johnny Mac's is Fam. I gotta look it up. Hold on. I gotta find it in here. It's Fam Paranormal, I think. Yep, there it is. Where'd it go? Yep, I was correct. And here is his. He's starting to get underway with doing more of this stuff. His name is Johnny Mac, but his channel. His channel is Fam Paranormal. And there you go. Those two guys. I don't know. How do y'all feel about that kind of stuff? Do you all say, yeah, we don't get mixed up into that, or does it not affect you? Because I'm trying to work through my fears. And this trial has brought out a lot of stuff for me. I feel like I'm choking myself. Oh, that's much better. There we go. This trial has brought out a lot of stuff from, just growing up and whatever and different things. And it's like, oh, okay, yeah. So, hey, Susie, sorry. Oh my goodness. Wait, did I miss anybody? I think it's just Susie that I saw. Lemon Curta came in and Susie came in. Does Luna Luna, you like that kind of stuff too? Yeah, I'm gonna next time they do something, I'm gonna take a peek. Some of it I'm like, yeah, I don't know if I really believe that that's what's being seen, because I'm still skeptical and whatever. But I also sometimes I go, yeah, okay, I gotta switch off because it's starting to get to me. The thought process behind the paranormal stuff. But Google says it's Dine and Dash. What's that, Linda? Oh, D&D, Dungeons and Dragons. Dine and Dash. Dungeons and Dragons. I think one time I sat in and watched that game being played, and at the time I was fresh out from under all the stuff I grew up with, and I was like, oh, this is the last time I'm ever doing this, because it really did I let my mind get to me a little bit on it. So yeah, I don't know if you've heard of it, Linda, but got the dishes done. Oh, were you over there doing dishes while we were listening to this lovely testimony? So so he as in Johnny Mac has one coming up with a cemetery where they get messages on the spirit box. Now I'm sorry, but I may be not the best person to ask about the spirit box thing, because oh, I'm sorry. I struggle with the belief that that is an actual thing, but it's, some people do believe that that's, that's the way to get to the spirits and have them talk and whatever. But my husband, every time he hears it, he didn't grow up with any, you know, background like I did or anything, but he's all like, yeah, I know that radio wave stuff and it's all a bit, anyway, not to ruin it for people, but I was always that kid at Disneyland that would say, I see a zipper. So, but the spirit box thing, not to take away from anybody else's belief in it, I struggle with that one a little bit. But then again, I'm also that person that, if you go to a spirit medium, are they really getting something? Or I'm that person too. So so Lemon Curd says, I love paranormal stuff, even though I don't buy it at all. It helps me sleep. Oh, that would not be what it would probably mess me up in my sleep. But eh, oh, what a good hubby. But it is kind of neat to see how other people perceive things. So that's why sometimes I'll sit in and hear kind of stuff like that. There's another channel by somebody named Siwa Moon. She also does some of the stuff, and she'll do the spirit box. And I've sat and listened to her do it too. So it is, if it's your thing, I'll put hers in too. Hers is her channel is this one. That one. She is what she considers herself to be, a witch. So just know that going in, and if that's a thing that you're like, yeah, no, then just know. But she's awesome. I like her. She's a sweetheart. And I think that's I think that's the first time that I've ever shouted out her channel. So what time did they say they were going to be back? Let me see. Let me check Twitter. Usually if I look, I can tell by Nate. So we got about 2 minutes left, or 20 to 30 minutes. Yeah, he is right. They say 20, but they run 30. So not into the spirit box. Yeah. My husband is into electronics and stuff like that. And so he kind of has he likes to poop on that one. On the spirit box. Whatever. I don't know. If it's fun, if it's, it doesn't hurt anybody. So it is what it is. Hey, Mia, good to see you. Some people are like, what in the heck did I just walk into? Oh. So, oh, don't push that button. I almost shut us down. So, I'm noticing something's not on my side, and I'm trying to find it, but I couldn't. I hope you're doing well, Mia. So let me see. Linda says, I've watched shows before that whole families had to move out because they have had or have a bad ghost or demon, very scary stuff. Coming from the background that I've got, I think that there's more fear placed on the people that are in where I came from. And so there's a reason why we kind of see what I call wee beasties everywhere, or, worried about that kind of stuff because of what's placed on us as far as beliefs and stuff. So it takes a long time to once you come out from under that stuff, it takes a while to get that out of your head. Oh, that hair's driving me crazy. Sorry, I gotta fix something. There we go. No, oh no, hold on a second. Hold on a second. There we go. That was driving me crazy. Uh, who had a long phone call? Anywho, they should. So we're waiting. Where are we at now? So going through and listening to these messages and stuff between Chad and Lori, it's just, you feel like you're looking in a window or whatever, that you're peeping into something that you really wish you weren't peeping into. He's an odd duck for sure. With his explanation of the way he describes the stuff that he's trying to say to her in a romantic way. It's definitely not Harlequin romance. It kind of reminds me, it kind of reminds me of the Psalms. There's a Song of Solomon, is it? Or whatever it is, that one Bible verse that everybody makes fun of. I think I mentioned it to somebody behind the scenes about a part of the scripture that kind of sounds like what he's writing and how he writes it. It's the one about never mind, I'm not going there.
Rise.
Oh,
District Court's again in session.
Saved by the Bell. Saved
Thank
by
you.
the
Please be seated.
All Rise.
All right, Mr. Bailiff, we'd like the jurors brought in, please.
Thank you.
Stevie, get the All Rise. Get the All Rise, Stevie. Let's see. Stevie says, oh, maybe I called and I missed an hour. Oh my goodness. Yay, family. To make it fresh and pot of coffee. Ooh, I had my coffee. That's how I got through doing all those posts.
All right, please.
All rise again. Oh, defense is wearing the red M tie. Oh, he does have the tie on. I didn't even look again.
Here's our President Counter for you, Your Honor.
Thank you. Please be seated.
Here we go.
All right. We're back on the record on CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Continuing with direct examination. Agent Hart, if you'd like to continue, Ms. Blake, you may.
Thank you, Your Honor. And may I go back to publishing?
Yes, you may.
Should I turn my camera off this time?
And Agent Hart, we'd left off with this slide. Do you recall that?
Yes,
And we'd left off talking about the finish line.
correct.
Was this the last slide that was part of this particular series of texts?
Yes, it was.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date that these messages were being exchanged?
Yes, this text exchange is from September 3rd of 2019
Who are the messages being exchanged between?
between Alex Cox and his sister Lori Vallow.
Do you know where Lori Vallow was living at this time?
Yes, both Alex Cox and Lori Vallow moved to Rexburg, Idaho from Arizona on September 1st of 2019.
Was there anything else about these messages that stood out to you?
Line 264 from Alex Cox to Lori Vallow, where he indicates the network password is too many kids. And her response is funny, exclamation point, exclamation point.
When was the last known sighting of Tylee Ryan?
Last known sighting of Tylee Ryan was September 8th of 2019.
And when was the last known sighting of JJ Vallow?
September 22nd of 2019.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, is this a continuation from the previous slide?
Yes, it is.
Who are these messages between?
Again, between Alex Cox and Lori Vallow.
What about these particular messages caught your attention in relation to the investigation?
In relation to the investigation, these few messages provide a little bit of insight as to Alex Cox's role within this small circle of people, Lori Vallow and Chad Daybell.
And in that line, do you know what the Z's was referring to based on your investigation?
I do.
What would Z's be in reference to?
Z's is an abbreviation for zombies.
And then when we look to that line 261 in particular, was there something about that that stood out to you?
Yes, Lori Vallow indicates that they're trying to get to the bottom of what we need to do to eliminate them completely. And then she indicates to Alex Cox that he would be told also. And so to me, that sheds light on
Judge, I'm going to object. It's becoming a narrative and it's calling for speculation.
Overruled.
it sheds light on Alex's knowledge, how much knowledge he has, and that he too would be told what to do or what his role would be.
In your review of these messages, was Alex included in the text regarding death percentages?
He was not.
And this message indicates Alex would be told.
Correct.
And what was Alex's response?
Excellent.
And again, those messages were exchanged on September 3rd of 2019.
Yes.
What are we seeing in this slide?
This slide contains a very short, it's just a few seconds, video that I located within the iCloud. As part of our investigation, we went to great pains to try to determine when Tylee was killed and when was the last known sighting that we could verify. And that last known sighting is on September 8th, 2019. This is a video of a trip that was taken with Lori Vallow, Alex Cox, JJ, and Tylee to Yellowstone National Park. It's the last known living proof for Tylee.
And this is 5 days after the messages about eliminating zombies completely,
Yes,
and 5 days after the messages about Alex being told what to do.
yes.
And who else was in that video?
Tylee is hugging her younger brother, JJ, and Alex Cox is standing off to the side.
Can you tell us what we're seeing in this slide?
Yes, in a similar vein, we searched for what would be the last known sighting or living proof of JJ. And this is what I located on the iCloud. It's from September 22nd of 2019 at 10:46 a.m. in the morning. Subsequent to this video, there are no other photos or videos existing in the iCloud of JJ.
And again, where were JJ and Tylee's remains found?
Chad Daybell's property.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
These are from September 24th of 2019.
Who are these messages between?
These are messages between Sydney Woodbury and Lori Vallow.
And in relation to this date, was it significant?
Yes,
And why was that?
The date is 2 days after our last known living proof for JJ.
What else about these messages stood out to you in relation to your investigation?
These are the first lies we can find documented by Lori Vallow regarding JJ and his whereabouts.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, there's 3 messages here that all contain a different date. Is that correct?
It is.
At the time these messages were exchanged, was Charles Vallow alive?
No,
Was Tylee Ryan believed to be alive?
no,
JJ Vallow believed to be alive?
nope,
Was Tammy Daybell alive?
yes.
Looking at the first message, can you indicate the date that was sent?
First message was sent on October 3rd of 2019.
Who was it being sent from and who was it going to?
This was a message from Chad Daybell to Lori Vallow.
Was there something about that message that stood out to you?
Yes, Chad Daybell indicated that he was so excited to go on a date with Lori Vallow.
And the next one, can you indicate the date?
It's the following day, October 4th, 2019.
And who is that message from?
That's a message from Lori Vallow to her brother, Alex Cox.
And what about that, if anything, caught your attention?
Well, at this point, they had both Alex Cox and Lori Vallow had moved to Rexburg, Idaho, were living in Rexburg, Idaho. And the investigation indicates that Tammy or Tylee and JJ were both deceased at this point. Lori Vallow says to Alex Cox, we are supposed to go on a quote, real date tonight, but are discussing it. And then she indicates perhaps an evening at home would be better, so we are not out and about.
And again, at this time, Tammy Daybell is still alive.
She is.
Where was Lori Vallow living at this time?
She was living in Rexburg, Idaho, which is a very short distance from Sugar City, where the Daybell residence was located.
And then looking at that last message, can you indicate the date?
October 5th, 2019.
Who was that message being sent from and who was it going to?
So this is a message from Chad Daybell to Lori Vallow. And then there will be 2 more slides that are a continuation of Chad Daybell reaching out to Lori Vallow approximately 12 hours after the prior text indicating that an evening home may be better rather than a real date.
And in that last message, can you read that last message into the record?
Hello, sweet angel. Big news about Tammy. Please let me know if you are awake and can talk. I love you, exclamation point, and then heart and lip emojis.
There's an indication in there from Chad to Lori that there's big news about Tammy. Is that correct?
That's correct.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
Yes, the date is October 5th, 2019. And the times are within minutes of one another, as well as within minutes of the prior text where Chad Daybell indicated he had big news about Tammy.
And looking at these messages, were there things that caught your attention?
Yes, there's 2 text messages on this slide and then 2 more text messages. All 4 of these text messages are from Chad Daybell to Lori Vallow. I found no response from Lori Vallow to these messages. But in these messages, Chad Daybell is providing an explanation, a narrative indicating that Tammy has been switched and that there is a demonic entity that is now in Tammy Daybell's body that she wants removed. And that word removed, I think, is critical.
And do you see in here a reference to the name of the demonic entity?
Yes, the name that Chad Daybell assigns to this demonic entity is Viola.
Judge, I'm going to object, move to strike. There's no testimony regarding who assigned what.
Overruled.
We talked about the word removal based on your review of the iCloud account, your review of other things involved in this investigation. What was significant about removal?
Removal indicates the physical death of the person who has the demonic entity.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, I believe you indicated this is a continuation from the previous slide.
It is. These are all, I believe the very first text message was 4:36 a.m. And so the final text, the final and 5th text message in this string, all from Chad Daybell to Lori Vallow, is at 4:54 a.m.
And again, what day?
on October 5th of 2019.
What about these particular messages caught your attention in relation to the investigation?
In relation to the investigation, line 769 is a crucial piece of evidence from the iCloud that is a very specific reference to the alleged crimes involving Tammy Daybell.
Judge, object. Mischaracterization, speculation, argumentative.
I'm going to sustain that as argumentative.
We had just talked about the meaning of the word removal in the investigation. Do you see reference to removal in this line?
I do. Chad Daybell writes, not fully sure of the timing for removal, but once her actions verify the differences, I don't want to wait.
What happened on October 9th of 2019?
October 9th.
Answer, Judge.
What was that?
Objection. I asked and answered.
Overruled.
On October 9th, 2019, was the first attempt on Tammy Daybell's life.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were being exchanged?
These are messages exchanged on October 19th, 2019.
What was significant about October 19th of 2019 in your investigation?
That is the date of Tammy Daybell's death.
Who were these text messages being exchanged between?
This is between Lori Vallow and an individual who wasn't identified by name within the iCloud. So I can't tell you who this is that's telling her this information.
What was significant about these messages? Or let me withdraw that. What caught your attention in relation to these messages?
Simply that someone knew that Tammy Daybell had died and then provided that information to Lori Vallow, who was in Hawaii at the time.
Do you know where Chad Daybell was at the time?
In his residence in Sugar City, Idaho.
Do you know where Alex Cox was?
Alex Cox was in Rexburg, Idaho.
And moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
Again, on October 19th, 2019.
And who were these messages being exchanged between?
These are between Lori Vallow and Chad Daybell.
What in relation to these messages stood out to you in relation to the investigation?
Primarily the timing of the messages in conjunction with Tammy Daybell's death. And then this is the first in a series of messages over the next 24 hours or so between Chad Daybell and Lori Vallow subsequent to Tammy Daybell's death.
And again, Tammy Daybell was pronounced dead on October 19th of 2019.
Yes, the call, the 911 call was approximately 6 a.m. on October 19th, 2019.
So the same day these messages are exchanged.
Correct.
And move to the next slide and pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
These messages are on October 20th, 2019.
And who were these messages between?
Chad Daybell and Lori Vallow.
And this is the day after Tammy's been pronounced dead?
Well, the first two messages, as you can see, are just past midnight. So they're approximately 18 hours after Tammy Daybell's death. And then the last two messages are approximately 25 and a half hours after that 911 call regarding Tammy Daybell's death.
What else about these messages stood out to you in relation to the investigation?
Well, line 527 on that date is a text from Chad to Lori Vallow, where he indicates, "I love talking with you. It's baby night, so come get me later."
Do you know where Lori Vallow would have been at that time?
She's in Hawaii.
In the messages that you reviewed shortly after Tammy's death, any expression of grief by Chad Daybell regarding his wife's death?
None.
Any expression of grief by Lori Vallow?
None.
And if you recall, when you testified previously, you'd reviewed messages around the time of Charles' death, is that correct?
Yes.
Any expression of grief by Lori in those?
None.
Any expression of grief by Chad in those?
No.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
October 20th of 2019 in the early morning hours.
And who are they being exchanged between?
Again, it's a continuation between Lori Vallow and Chad Daybell.
Were there things about these particular messages that stood out to you in relation to the investigation?
We're now getting into the logistics of Chad Daybell and Lori Vallow being together subsequent to Tammy Daybell's death. Lori Vallow actually invites Chad to jump on a plane and come to Kauai. And Chad Daybell responds that she should come back to the mainland so that they can spend the night together on Thursday, and then indicates wanting to look for a condo so that they could return to Kauai at the first of the month, meaning November.
And do you recall from your previous testimony reviewing some messages regarding a plan to be in Kauai?
I do.
And who was that plan between?
Chad Daybell and Lori Vallow.
Do you know if Chad and Lori were ultimately married?
They were
Where did they get married?
on the island of Kauai.
Do you know where Chad Daybell and Lori Vallow moved to?
The island of Kauai.
And this conversation took place about 25 hours after Tammy Daybell had been pronounced dead.
About 26 hours after the 911 call by Chad Daybell to indicate to authorities that his wife was dead.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, would you indicate the date that these messages were exchanged?
October 20th of 2019.
And are these a continuation from some of the previous slides we've reviewed?
Yes, they are.
And who were these messages between?
Chad Daybell and Lori Vallow.
In relation to your investigation, what stood out to you with these messages?
Again, it's a continuation of the fulfillment of their plans to be together. The first line, 5118, Chad Daybell indicates a workout plan for Lily, who is Lori Vallow, that he wants to tighten his abs, get a full body tan, grow his hair out, and that it could be really good for both him and Lori Vallow.
And in that last one, 516, do you know who Raphael and Lily is referring to?
Those are, again, alternate names for Chad Daybell and Lori Vallow.
And is there an indication there about how much they will be together?
100%.
Moving to the next slide, I'm going to pause to allow the jurors to read. Agent Hart, can you please indicate the date these messages were exchanged?
Yes, this is the conclusion of this text string, and the date is October 20th, 2019.
And who are the messages between?
Lori Vallow and Chad Daybell.
Was there anything that stood out to you in relation to the investigation in these messages?
Yes. In line 515, you have Lori Vallow indicating how consuming her love is for Chad Daybell. And then of note, line 514, Chad Daybell responds, "I know exactly how you feel. I'm feeling sad, but it isn't for the reason everyone thinks!" Exclamation point.
Through the investigation, did you learn what the connection between Alex Cox and Chad Daybell was?
Yes.
What was that?
Alex Cox was an adherent of Chad
Judge,
Daybell.
objection, argumentative.
Sustain.
Did Chad beat Alex through Lori?
Yes.
Based on your investigation, review of messages, and other things, would Alex do as Chad asked?
Judge, objection, argumentative.
Overruled.
Yes.
Did Tammy Daybell know Alex Cox based on what you learned in the investigation?
No, she did not.
Was the only connection between Tammy and Alex Chad?
Correct.
Moving to the next slide, I'm going to pause to allow the jurors to read. And Agent Hart, can you indicate the date these messages were exchanged?
Yes, October 23rd of 2019.
And who were the messages being exchanged between?
Lori Vallow and Chad Daybell.
And do you recall in a previous slide talking about a message where Alex was going to be told information also?
Yes.
What about these messages stood out to you in relation to the investigation?
In relation to the investigation, primarily lines 482 and 481 stood out to me. In line 482, Lori Vallow indicates she's had a bad dream about Al. And primarily line 481, Lori indicates that Alex Cox would be the one they use to get us both. All this alone time is not good for him. So something that Alex Cox knows is a risk to Lori Vallow and Chad Daybell.
Based on your investigation, review of the iCloud, and other information, who was the they being referred to?
Objection, speculation.
Overruled.
I believe that is a direct reference to law enforcement.
What is Chad's response in line 479?
Chad Daybell indicates I will try to reach out to him later today.
So Chad was going to be the one to reach out to Al.
Correct.
And Lori was requesting Chad's help with talking to Al.
Correct.
And again, through your review of the messages, who was seeking information?
Primarily Lori Vallow,
And who was providing the answers?
primarily Chad Daybell.
I have no further questions.
All right. Thank you, Ms. Blake.
That
All right,
was a
Ms.
lot.
Prior cross-examination.
Thank you, Judge. Agent Hart, there was a discussion about when you're investigating missing children, who the potential folks that you would look to if you were starting your investigation. Do you recall that discussion?
Yes.
And wouldn't it be fair to say that an obvious person to look for or look at when you're investigating missing children would be a new husband?
In addition to others, yes, we would look at the parent or the husband. I guess my point was you can't put blinders on. You can't exclusively hone in on one person at the onset of an investigation.
Right. And it would be inappropriate to do that. I mean, when you're looking in conducting an investigation, wouldn't it be fair to say that any and all evidence that you obtain, you should look at all leads of evidence and not target your investigation in one channel? Would that be fair?
Yes, that's what we did.
Okay. And that's what you're, as far as the FBI, that's what you did, right?
I participated in dozens of meetings with the Rexburg Police Department and the Fremont County Sheriff's Office. It's my belief that's what all of us did.
Okay. So again, just to reiterate, it's your contention that you didn't fail to investigate or look into evidence that might lead you in a different direction. Would that be fair?
That's correct.
Okay. Now, as part of your FBI training, you talked about that you were involved in the task of looking for identifying missing children, correct?
Yes.
And as part of that FBI training, is it your experience or the FBI's experience that they ever utilize the use of a medium to try to locate or talk to children who have passed on?
It's extremely common for people who claim to have those abilities to come forward, but no, the FBI does not employ mediums in its investigations.
And I didn't say employ, I said utilize, but do you know the name Allison Dubois?
I believe I'm familiar with that name, yes.
And Ms. Dubois is a medium who claims to have the ability to talk to children and to help.
Objection, Your Honor. Counsel's testifying. Move to strike.
Sustained.
What is your knowledge of Allison Dubois?
It's my belief that she holds herself out to be a spiritual medium.
And that spiritual medium is being able to talk to children who have passed on?
I couldn't say specifically what abilities she claims to have.
Okay, and I don't want to say employ, but has the FBI or any agency you've been involved in ever employed Allison Dubois or any other medium in helping gain information?
Objection, Your Honor. Relevance.
Overruled.
Gain information about the whereabouts or the circumstances surrounding the death of a children or anyone in particular.
Well, Mr. Pryor, when I said employ, I think I mean the same thing you do as utilize,
Okay,
not pay money to. I've never spoken with Allison Dubois. I've never requested her services. To my knowledge, nobody in this investigation requested her services. Many times these people come forward offering their services and offering what they claim to have seen.
so you are familiar that there are people out there who, as a professional occupation, claim to be able to engage in these spiritual exercises, for lack of a better word, correct?
Objection, Your Honor. Relevance.
Sustained.
So would it be fair to say that if Chad Daybell placed himself out as someone who claims to be able to have these spiritual gifts, that in itself is not unusual? Would you agree with that?
I don't believe it's common.
Okay. Your concern is that the number of text messages in reference to Tammy and the children, that's where you say that's where we potentially have a problem, correct?
Given what happened to Tammy and Tylee and JJ, yes.
Okay. Now, I noticed during your dissertation with all of your exhibits, on around 8/11, August 11th of 2019, it appears that there are some captions that were left out regarding a breakup between Lori and Chad Daybell. Do you recall that?
I believe those were included in the first testimony that I provided a number of weeks ago.
Okay, and those were not included in today's testimony, is that right?
They were not part of today's testimony.
Do you have a specific recollection of what was involved in the language that was used that you could read and provide us in terms of testimony regarding those emails?
Yes, I can certainly give you my best recollection. It won't be verbatim, and if you want verbatim, we'd have to go back to the exhibit that was used during my testimony previously.
And Judge, previously, the state and the defense stipulated to the admission of the Lori for Style contents of that particular account. I'm holding in my possession Exhibit 7U, I'm going to ask that the court mark this as an exhibit and move for admission by, I don't know that the state has an objection to that.
The state does not have an objection. I just wanted to clarify which ones.
Very well. We'll get that marked for you, Mr. Pryor, and then.
Thank you, Judge.
Can you clarify what's in 7U?
Judge, it's a content of approximately 4 text messages between Lori Vallow and Chad Daybell dating from 8/11 of 2019.
All right, exhibit 7U is being marked and will be admitted.
Thank you. Judge, may I have the court's permission to publish?
Yes,
And it might take me a minute, Judge. For more than a minute. And Judge, if we could start publishing.
all right, we will.
Now, officer, I apologize. Agent, line 856 talks about from Chad Daybell to Lori Vallow, the next 2 days will be torture. Do you see that?
I do.
Then there's a comment from Chad, makes a comment, and could you read that thankfully?
Thankfully, I will be alone most of Wednesday and beyond.
Okay, and then we go to line 854. Are these in, there's no text messages that are in between each of these. Is that correct?
So in the iCloud, there can be. So in between 856 and 854, Lori Vallow could have gotten a text from a friend about lunch. And so they're just arranged and given a line number based on the date and time. So that's how this works.
Okay, so the time on the first one, 856, is at 9:56. The 854 would be the next correspondence from Lori Vallow to Chad, correct?
Yes.
And if you could read that entire text message starting with the word is.
Is that what he wants? For me to sit around waiting for you endlessly and you miserably wasting time? It just doesn't feel right! Exclamation point.
Okay. Now, you talked about the manipulation that was engaged in these, many of these, and you said, use the word many, from Lori Vallow to Chad Daybell. Is this an example in your mind of Lori Vallow again manipulating Chad Daybell?
Absolutely. It was a two-way street. Lori Vallow would manipulate Chad Daybell and vice versa.
Okay, and Chad's manipulation would be talking about the religious knowledge that he claims to have in this vast wisdom. Is that right?
Yes.
Okay. So on 2 levels, we have manipulation, at least according to you. We would have manipulation because someone's claiming to have some religious knowledge and espouses that by trying to impress Lori Vallow with that vast religious knowledge, correct?
I think it's more than knowledge. I think it's direction.
Okay. And then in Lori's case, this is manipulation and trying to get Chad to do what she wants him to do, correct?
Yes, I would agree.
Okay. Okay. And Judge, could we unpublish at this point to like move to the next slide?
Yes.
Thank you, Your Honor. Okay, and then if we could publish again.
Go ahead.
And then again on 8/11, it talks about Chad to Lori Vallow. I'm frustrated. I'm sorry, honey. And then let's go to line 843, which appears to have occurred at about the same time the first text. And if you could read line 843, starting with you.
You can't just keep tearing my heart out. I really can't take it anymore. I'm sorry.
Okay. Okay. And then let's go down to line 841 and start with reading that one for me.
What about the past 2 days? I didn't even get to talk to you on your birthday. I'm clearly not a priority. I just don't want to be so sad all the time and do heartbroken.
And again, in your professional experience with dealing with this case, is that another instance where Lori Vallow may be trying to manipulate Chad Daybell?
Certainly.
Thank you. And Judge, if we could unpublish again.
Yes.
And let's publish again, Judge. Okay. And then if you would read line 840.
If you really loved me, you wouldn't want that either.
Okay. And then Chad Daybell responds. That was from Lori Vallow to Chad, correct?
Yes.
And then 2 minutes later, Chad discusses that he couldn't have talked. The girls were there. And then he expresses his true love for Lori Vallow, correct?
Yes.
And then if you would be so kind, 2 minutes later at 10:15, Lori Vallow texts Chad Daybell. And if you could just read the entire line starting with you.
You should give all of you love and your attention to your wife and family. I'm just a distraction. Go have fun with your family. I really do want you to. I just can't be in the way anymore. If things change, then we can talk. But we have nothing until things change anyway.
And once again, I don't want to keep reiterating this, but this is another example of Lori Vallow attempting to manipulate Chad Daybell. Would you agree?
I would.
Okay. And it seems a little bit final. And it seems as if that the suggestion here is on 8/11 of 2019 that there's a breakup between Lori Vallow and Chad Daybell. Do you agree with that?
I do.
Judge, we can unpublish this.
All right. All right, that concludes cross. Any redirect?
Yes, Your Honor.
Go ahead.
Oh, I'm sorry.
Your Honor, I would request permission to publish from 183B, the printout of the PowerPoint. I can use the drive if necessary.
All right, we'll get you the exhibit on the drive.
Okay, while they're doing that, I'm going to put this up real quick for a second.
Agent Hart, you were asked about manipulation by Lori Vallow from council. Do you recall that?
I do.
Through your investigation, did you also find manipulation by Chad Daybell?
I did.
Did you find that manipulation around the same time of the breakup?
I found it throughout the entire course of the investigation.
And again, through the investigation and based on your review, who would determine someone was dark?
Chad Daybell.
Who would determine if someone was a zombie?
Chad Daybell.
Who would determine?
Judge, I'm going to object at this point. It's going beyond the scope of cross-examination.
Overruled.
Who would determine death percentages?
Chad Daybell.
And Your Honor, I would request permission to just publish one page of the slide, but the printed out for ease.
Yes, you may publish the printed version on the Elmo if you'll identify what it is when you do that.
Yes, it is slide 18 from the printed version of Exhibit 183B. Agent Hart, who is the one that indicates there is a plan being orchestrated?
Chad Daybell.
And do you see the reference in there to the children?
I do.
Do you know where Tammy Daybell's body was located when she was pronounced dead?
Tammy Daybell's body was located in the bedroom in their home.
Where were the bodies of Tylee and JJ located?
Tylee and JJ were both located on the pasture property of the residence.
And was that the residence of who again?
Chad Daybell.
I have no further questions.
All right, thank you. That will conclude the testimony then of Agent Hart. Does the state have any additional witnesses to call in its case in chief?
We do not, Your Honor.
All right, so has the state rested at this time?
Judge, if we may have a brief sidebar.
Yes.
Okay, state's about to rest, which will end today's testimony. And tomorrow prosecution will start, defense will start their case. This was an amazing end to this. She is fantastic at pulling all of this together. Wow. I got no words. I don't even think we're going to have a lunch or anything. I think we're going to end right after they get back. Once they rest, they'll end for the day because we already know that it was going to be a short day. I will say that that really got to me. I tried to keep my face as not as odd as it was while I was trying to do all that quick uh copying and whatever, screenshotting and all that. But whew, that was powerful. Her way of how she handles her voice and how she pulls you into what when she asks the questions, I think is one of the best that I've seen. She reminds me, I'm just going to say it, she reminds me of Camille from Johnny Depp. And yes, very much so. She came, if there were objections with her question, it was very well done. It's like, I feel like she had the questions she would ask if she got an objection, that she had those ready to go in front of her so that she knew to switch to the next one, word it this way. Like she got the first part out she knew would be objected to probably, and then switched it and put in the one that wouldn't. That's kind of how I felt when she was doing it. When Pryor does it, I always feel like he's irritated that it got objected and wasn't prepped for the next question. But she was amazing with that. Very good job. Hey, Jen, good to see you. Anybody else that I may have missed? That Linda, that absolutely was intense. Let's see. So I'm gonna put up this. Oh yeah, I'm gonna put up the stuff that I put the stuff that Dana put up about the malachite. That was, I believe, the same stuff I put in very early on, and it was right after somebody had come in and given me this little theory from Reddit about malachite, and I put it up there, and it might not have been well received, but I just thought it was interesting. I don't think I hold it as a probability, but it's just, another thought process. It says malachite extract is often used in cosmetics and skincare products because of its antioxidant properties, which can protect the skin from environmental stresses. Now, wait a second. Is this different than malachite green? Let me go back up here, because I think I saw something malachite green. So there are two different kinds of malachite. Yes, malachite green. This is it right here. Sorry, when I read it, it didn't make any sense. Malachite green is toxic to humans and can cause irritation to the skin, eyes, and respiratory tract if swallowed or inhaled. Symptoms of toxicity include carcinogenesis and mutagenesis. And they're coming back, but chromosomal fractures, all that stuff. So that's different than the stuff that you were mentioning over here. Okay. So yeah, there's an extract. And there's that. Okay, they're coming back.
All right, we just had a sidebar to discuss some scheduling matters. At this time, I had inquired from the state if the state had another witness to call at this time, or whether the state had concluded its case in chief. Ms. Blake?
The state does not have any additional witnesses. The state rests.
All right, the state is now rested. Ladies and gentlemen of the jury, in terms of our scheduling, that is going to conclude the evidence portion for today. We did not provide lunch today, believing we'd end here early. However, before you leave, you'll be delayed a little bit while the jury commissioner is going to just talk to you about a little additional information and scheduling at my direction. And so we will take up those matters with you shortly. And at this time, then we'll take a recess. And then if the parties wish to come back on the record for any motions outside the presence of the jury, we can do that as well. So we'll take our recess at this time and let the jurors be excused to the jury room. All right.
So I do think that they will come back, and I believe we will be able to hear arguments and stuff. I think. We'll see.
All right, thank you. Please be seated. I'll note that the last witness, Agent Hart, is still, I'm advised by the state, I believe, going to be held under subpoena potentially for rebuttal. Is that correct?
That is correct, Your Honor.
Okay, we just advised the witness he's done for today, but he's still subject to the exclusionary order. At this time, also then, I do want to take a recess here because I do want to meet briefly with the jury commissioner, and we'll take a break. And then Mr. Pryor, is the defense intending to make any motion today?
Judge, I anticipate making a motion, a general motion for a directed verdict, Judge. I'll describe it that way.
Okay. Why don't we plan on that? I know it's maybe an inconvenient time, but in about 30 minutes probably. So
Thank you,
10
Your Honor.
after. We'll take the motion up then.
Thank you, Judge.
Okay, thanks. We'll be in recess until then.
All rise.
Oh, okay. Yeah, it's falling along right along like we thought it was going to. And kind of figured there would be a directed verdict after this, or that I kind of had a feeling that that's what was going to be. So anyway, so I think that I do. So I wanted to look at this malachite thing. I do know that too much copper can make you sick, which is why if you use copper cups and whatever, they have to be lined with tin inside, so you're not absorbing the copper into the drink and then drinking it. So I wonder if that is partially why it's a toxic. There's a toxicity to it. Well, I mean, duh, but I mean, as far as the difference between malachite and malachite green, is there a difference between those two? But I'm sure some of you probably would like us to move away from this malachite talk since it was not so well received the first time. But I guess, the last thing we really to say about the malachite is that it was just, this is probably what it was all about, as far as the reason for it being in this trial. Probably that. Here, oops. Let me put the banner down. Where'd it go? There it is. There. That way you can kind of see it. Probably because of this kind of thing. It had to do with their thoughts on what malachite meant to them and the energy of the stone and that kind of thing. And why it was used in the wedding and why it's a part of their thing. But I think it's the first part, death and resurrection, to me, also transformation. So his whole thought process is to get out of the marriage he was in, because he was not a happy camper in that marriage. So I put that together because I kind of wanted to put a little bit more about the malachite rings and kind of try to move away from the poison part of it. But so we got half an hour to sit and wait for them to do a motion for directed verdict. And if we don't know what a motion for directed verdict is, it is where, okay, sorry. Can't see. Oh, there it is. So a motion for directed verdict is a request to a trial judge to rule in favor of one party before a case is submitted to a jury. The motion argues that there is not enough evidence for a reasonable jury to reach a different conclusion. If the judge grants the motion, the jury will return a verdict for the party that requested it. Let me see. And I'll put some more in here. 1 second. Where is it? There it is. A motion for directed verdict is only appropriate if a reasonable jury could not find in favor of the opposite party. Opposing party. Judges have discretion when deciding whether to grant the motion, and they are often reluctant to take the case out of the jury's hands. So directed verdicts are not common. Yes, I have only seen a mistrial. Sorry. Hold on 1 second. Where is it? I have seen a motion for mistrial granted a few times, but most of the time these things are not granted. They are just a formality as far as trials go for the appellate portion in case there's an appeals process that happens. I think that there's going to be some appeals stuff with this case because I think that Chad is going to argue insufficient, what do you call it? Insufficient representation. Or he's going to try to, because Pryor has tried from the get-go to get out of this case because he was not death penalty qualified. And see, in a civil case, that's a different one. We're not in a civil case. Lawyers can make a motion for directed verdict after the plaintiff's or government evidence presented. In a criminal case, the defendant's lawyer can ask for a motion to dismiss the charges. So there you go. And then there's, of course, federal. This one here. I'll put this in too so that it is complete. And in federal courts, directed verdicts have been largely replaced by judgment as a matter of law, which is governed by Federal Rule of Civil Procedure Rule 50. So there you go. So I'm going to read back and see what you guys are saying. Let me see. We are at, Nate mentioned it. Let me see. Did I write that down? we're at, oh, he said it, but then I didn't write it down. What week are we at? We're at, yeah, I don't know, but we're 25 days, 24 and a half days. He said it. I forgot to write it down. Yes, right here. That's it. Yes, it's 7th. So we're at 7 weeks in. So 7 weeks for prosecution, and now the rest, which will take us through probably to the end of this month. And it depends on if there is a death penalty portion. If we get the death penalty, then there'll have to be a whole penalty phase. Oh, doesn't she? She does remind me very much of Camille in how she's really good. I mean, there's a reason that Camille got the promotion she got after the Depp case, because not just because it was a huge trial, but also because she was really good. Defense is, yes, going to call his 3 children. He has 4 or 5, whatever, but at least 3 of them he will be calling. Most of the so right here, most of the time when these directed verdicts happen, like I said, it is procedure. It needs to be put on the record for appeals reasons later on. So a lot of people who are first time watching a trial will be like freaking out because defense is going for mistrial, directed verdict, yada yada. But those of us who've been doing this for a while kind of sit there and go, okay, yeah, here we go. So get this in on the record. And we know that it's not going to be granted by the judge because they hardly ever are. And so we watch others. I watch new trial watchers freak out, and it's kind of funny. It's cute. Not cute, but you know what I mean. And my dog is going to bark because there's noise outside. Bella, go see your brother. This, yeah, they're barking. Hold on a second. Okay, she's quiet now. Oh, yeah. I let the one dog out, and he's outside enjoying the yard, and he's barking at everything out there. Jen, so Stevie says, someone, probably Jane, came in yesterday and said that she was their local. They said 17 more days were expected, so now 16 more. Yeah, I think that's about, it's going to run us to the end, at least to the 25th, I think, of this month. We could see this, I think his case is going to be extensive because it is a death penalty case, and then we'll have to see how long it takes after that before there is a final verdict. Yeah, we know, like, right, Dana? We've been doing this long enough. It's expected. And Linda says Lindsay Blake is excellent. She is very good. I was riveted, not just because I was trying to fly by and put all those things up on the screen for better viewing, even though they're fuzzy, but I was very impressed by her manner and her way of, when the objection happened, she was able to then immediately put up the next question. And that it was excellent. I cannot wait to see how much objecting there is during defense case. Jen says, wow, I think Nate thought it's possible that they get the case by Friday next week, but likely Monday, a week from this next Monday. Yeah. I'm thinking the same thing. I think we're going to have a week of this. For next week is going to be prosecution. I'm horrible at dates, but so I'm looking at the calendar. So being on the 16th, so we'll go into I say that next week will be in this case. And I say we have finalization. You think it'll take a week for Prior to do his stuff? I mean, think about how long it takes him to just do cross exam. I don't know. We don't know how many witnesses he plans. I would assume, but being that it's a DP case, his defense case will be a little bit more extensive than maybe Lori Vallow's was. But it depends on how he flies through his witnesses, and we don't even know how many witnesses he's going to. And will Chad Daybell take the stand? I don't know if they mentioned that in openings. I always forget to listen to that because a lot of times defense will say, you will hear from the defendant. And then I forget to listen for that. So I don't know if that was stated during the openings or not. So see each other. Can you imagine the jury can't speak to each other until then? Yeah. Concerning the trial. Right. Okay, so Jane says it was a media person whose buddy is reporting on this case. Jen says, no, what's also in the way is Memorial Day weekend. They have to be sequestered. So I don't know what they're going to do about that. And Stevie says, did I carry the bone properly? I feel like I need to cite my sources on YouTube. I try to get it right. Yes, I always try to do that too. I always try to make sure that because I rely on in this case, I rely on East Idaho News, Nate, big time for the information. And if I'm quoting stuff, I'll say Nate said. But if I'm listening and then taking notes of what he said and it's in my words or whatever, then I don't necessarily. Oh. Yeah, I don't really want to post. Sorry, I should have read it first. I'm trying to avoid the subject of certain somethings. You know what I mean? And Jen says she's never seen Granted. I don't know if I've ever seen it. I think mistrial and directed verdict. Let me see. I was trying to see if there was a directed verdict is a ruling entered by the difference between a mistrial and a mistrial. It just means something happened and the judge said, okay, that's a mistrial. Like if somebody does something, there have been cases that I've seen where stuff has happened that has caused a mistrial. One time it was because the judge accidentally misread something. He was an older gentleman and he misread something, and then they came back around and it was a whole deal. But I have seen it happen. I mean, Melly was a mistrial. That was granted. Remember that one? They still have not had that trial. And I don't even know what the date is. I haven't looked it up. Oh, I did that one already. Sorry. Mal is here. Hi, Mal. Let's just hope Pryor is brief in his directed verdict motion so we can get to the expected answer. DENIED. I had to spell it out. It was spaced apart. Stevie says, Jane, so not quite. I'll try to do that better. I've heard. No, and I don't want to talk about that other channel. we're not, I don't want that. Let's just avoid it, please. It gives me PTSD. All right. So another 9 witnesses for the defense in total, they told me. Okay. So the jury will be sequestered for the entire penalty phase. Yes. They mentioned Alison Dubois, and I cracked up, from Real Housewives of Beverly Hills. Alison Dubois. One of my favorite Real Housewives is Beverly Hills, but New Jersey is my all-time favorite. There's so much attitude that I love it. I can't get enough of it. I can't get it. Look at even you can't really see it, but my sweat. Oh wait, helps if I put that down. Seaside Heights, New Jersey, because I went to the boardwalk. I went to the shore. My trip is on my TikTok. I went to visit John Yates, and I got to walk and put my toes in the same sand that Melissa and Joe Gorga put their toesies in. I said it. I accidentally said Teresa, but I meant Melissa. I'm not a Teresa fan. Sorry. I'm very interested to hear Pryor tell me a story. I can't imagine what he will come up with. Jen says that means the jury will be put up in a hotel away from everyone else until the sentencing is administered. So, and Lemon is curious to see if Garth will be called. Garth Brooks. I don't, every time I hear the name Garth, I, in my head, do say Garth Brooks, but a lot of times I revert to the movie that I have mentioned when the other witness was up and he had a Garth, the accent from the movie that I was trying to remember the entire time I was there. I just actually quoted it to my son yesterday. So I apologize for thinking that you were the local to the trial. I will remember that you are in. Oh, that's right. I can't remember where anybody is. When is Memorial Day? May 27th. No, Jane says, no, the person I mentioned is, they're in the media and their buddy is reporting inside the court. Oh. Is that, Jane, is that Hidden True Crime? I know they're there. She's there with Nate. She sits near him often. Well, I think that I should retire. I got some of the big parts, but I'm satisfied that I'm bad at this. No. Mal says directed is like not enough. No evidence for juror to support any other conclusion. Yes. In simple, that's way more simple terms than I put up there when I quoted the whole thing that I Googled. Christy says, speaking of trials that are never happening, what about Sarah Boone? No idea. Y'all know the dates. Y'all put it in the chat. And Melly is now set to be released in December 2024. Released? What does that mean? What do you mean released? I think Boone is undecided again. And Christy asks who is Melly. It's a similar trial to the YSL Young Thug trial. It's YNW Melly. He's also a rapper who's accused of the Big M as well. I forget how many in that one. It's been so long that I forgot the case particulars. And Mal says that episode was epic, Addi, with her vape pen at Camille's table. And Candy says Boone can't keep any attorneys, and she keeps making it difficult to get on the books. So do you think she's stalling, Candy? Do you think she's doing that on purpose? Susie says she was in Seaside as a kid. I walked from John's cottage to this boardwalk, and we walked all the way down the entire boardwalk to the other end, and then all the way back to where the little shore store is. That's Snooki's, the place where she used to work. That's where I got this t-shirt. I got it from Snooki's place. That's not a t-shirt, hoodie. I'm a hoodie girl, and I got my hoodie from that. So, and Christy says, "Oh, for some reason I thought you were saying you know what? Oh, no, YNW Melly. I forgot what the YNW stands for. No, it's his name. I'll have to let me look. What is the YNW? Young New Wave, right? Yeah. There's other things that I don't want to say. Yeah, just look that up. I'm not putting it up on the screen. Okay, never mind. Forget that. I don't think anybody ever really decided on what it stood for in the chat. I remember there was issues. I was constantly deleting words. I had to block words. Christy says, I live and breathe Bravo. It's on my TV 24/7. I don't even know why I pay a cable bill for one channel. I don't know if you know this, Christy, but I do recaps with John Yates on right now we're covering New Jersey. And right now it's every Monday we do recaps on John's channel. It's late in the evening, and because John's he's he lives right down the street from the boardwalk, so he's on that time zone, and we do that recaps on that show, and we also do it on. We normally we stopped doing it on the TLC stuff. John got fed up with it because the storylines are just so horrible now. But Angela Deem, who he's friends with, is going to be back on. Her parts are coming up for Happily Ever After. So on Tuesdays we'll be recapping that as well on his channel. But Bravo, he's moving more towards Bravo now, so we will be definitely probably doing more Bravo stuff rather than like I said on the front of this, I also like reality TV. I may not always put it on this channel. I don't know yet. Sometimes we may put both of our channels up live, but most of the time it will probably be just on his channel for recaps on the reality TV stuff. So we're kind of like a collab type thing. And then eventually I plan on having him over here because he and I want to do a thing together over here on a certain case. I'm not going to mention what the case is yet, but I think it would be cool. And we're kind of trying to figure out this logistics on that and when and whatever. But we want to go over a case together on over here. And Christy says, I'm watching Captain Lee as we speak. Oh, is that Below Deck? I love Below Deck. I love Below Deck Mediterranean, whatever all the Below Decks are. Oh, wait. What was that too? Oh, that was the YNW Melly release thing? I didn't know what it was for. Wait. Now, oh yeah, here's one. Yeah. I'm kind of sad about that because I have a love annoyed factor with Dorit, and I mean, I don't know. She's very affected. I say that when it's her domain, how she is and stuff, and I kind of liked him with her. They're cute together, but I don't like it when relationships break up unless the guy's a dirt bag or something. They're already separated. So yes, PK and Dorit. I think I saw that on Instagram. Are taking time. Oh yes, they're taking time apart. I really don't think that they're going to stay apart. I think they're going to work some stuff out because I think she has issues outside of what he can handle, and she's a lot for him. From my feeling and stuff with Dorit. Sorry, Dorit. Not that you would ever watch me in any way whatsoever, but but I do. I think she's a lot to handle, and he probably needs a break. Oh, did I say that? Oh wait. I forgot to put something up. Everything. Yeah, Jen says TLC was her guilty pleasure. I'm really starting to move away from it. Knowing what I know and being friends with John, and he's got an insight to all of that stuff. After realizing that these Blinken storylines are faker than heck on the more new ones, the OGs no, but the newer ones, yeah, it's all production crud that it really annoys me. Oh,
Mr. Court's again in session.
Thank you. Please be seated. All right, at this time, we're back on the record on case CR 22211623, State of Idaho versus Chad Guy Daybell. The court will note that the state has rested its case in chief. At this time, then, I understand the defense is requesting to have a motion heard. We do have the defendant here along with defense counsel. The state's also present with the prosecutors. The jury is not present in the courtroom at this time. This motion will be argued outside of the presence of the jurors. Mr. Pryor, if you'd like to make a motion at this time, you may.
And Judge, this is a motion for a directed verdict that is permissible under the criminal rules. I'm going to do this, Judge, in a general sense without getting into specifics, but I'm going to move for a directed verdict on the murder charges, specifically with Tylee and JJ. There is no indication that Mr. Daybell was present, took an active part in, or facilitated in any way the murder of JJ and Tylee. In regards to the conspiracy charges, there's no indication that there was any act that he took in furtherance. There's reference to significant religious discussions, but that in itself is not an action in furtherance of those charges. Lastly, Judge, in regards to the fraud, the only testimony I recall is that the insurance was upped from $10,000 to $80,000, and that there had already been a longstanding $300,000 policy from 2002. At this point, I don't think the state has met its burden regarding the fraud. And again, I don't think they've met their burden regarding the conspiracy on all of the conspiracy charges. And they have not met their burden in regards to the murder as set forth previously.
All right, thank you for the argument, Mr. Pryor. Who's going to be responding for the state?
That would be me, Your Honor.
All
And I
right,
think,
Ms. Beatty, you can proceed with a response from the state.
thank you, Your Honor. On a motion for directed verdict, Your Honor, the state is entitled to all reasonable inferences that can be drawn from the evidence. And I think the case law is pretty clear that a motion for judgment of acquittal should only be granted when there is no evidence upon which to base a verdict of guilty. And that is from State versus Vargas, 100 Idaho 658. Essentially, the trial judge must review the evidence in the light most favorable to the state, recognizing full consideration must be given to the right of the jury to determine the credibility of witnesses. The jury gets to determine the weight of the evidence, as well as enjoying the right to draw all reasonable inferences from that evidence. And that's from State versus Huggins, 103 Idaho 422. Going through the charges in this case, Your Honor, first beginning with the conspiracy to commit the first-degree murder and grand theft by deception related to Tylee Ryan. The state charged a series of overt acts, and the state has presented evidence on all of those overt acts. Number one being that the defendant endorsed and espoused beliefs designed to justify the homicide of Tylee Ryan. Specifically, statements made about her being dark. These beliefs were part of the defendant's teachings, and it would be very reasonable for the jury to draw the inference that these beliefs that the defendant was espousing were designed to dehumanize these victims and justify their homicide. As to number two, that his co-conspirator Lori Vallow changed the deposit on Tylee Ryan's JP Morgan Chase account to her BBVA account. We also heard testimony from the state's financial witnesses to that effect. Evidence that his co-conspirator and then mistress, Lori Vallow, moved to Idaho with his other co-conspirator, Alex Cox, as well as JJ Vallow and Tylee Ryan. Multiple witnesses testified to this. We heard evidence that the defendant himself did Google searches for the wind direction on September 8th of 2019, the last day Tylee Ryan was seen alive, and the day prior to when the state presented evidence that Tylee Ryan would have been buried on the defendant's property. That is directly related to the defendant. Number five, Alex Cox went to co-conspirator Lori Vallow's apartment where Tylee Ryan lived in the early hours of 9/9. Certainly there was evidence presented to that effect. And of note, there was also evidence that the defendant was in communication with Alex Cox at that time, and that Alex Cox's phone was in the vicinity of the defendant's residence. As to number six, that Lori Vallow never contacted Social Security. There was also testimony presented to this effect. The jury also heard that just weeks prior to Tylee Ryan's death, that Lori and Chad was aware that she would still be getting those Social Security checks after the death of Charles Vallow, which does link the defendant to that co-conspirator's actions in never contacting Social Security. Additionally, the seventh overt act, that from September of 19 to January of 2020, Lori Vallow continued to collect those checks. And during a substantial portion of this time, Your Honor, the defendant was living with her in Hawaii and enjoying the proceeds of those checks, another reasonable inference that the jury could draw. As to the first-degree murder charge of Tylee Ryan, which is count 2, the jury heard evidence that the defendant claimed that Tylee Ryan was dark, that he was, again, exchanging text messages with Alex Cox the day after she was last seen alive, that Alex Cox was in the vicinity of his residence. The jury heard evidence that the defendant texted his wife the morning of September 9, claiming that he had shot a raccoon and burnt some limbs. And then Tylee Ryan's burnt and dismembered remains were found on the defendant's property. her DNA found on the defendant's shovel and the defendant's pickaxe in the defendant's shed. So I think there's ample evidence on that count, Your Honor, and I think that does not merit even consideration of a judgment of acquittal. As to count 3, I won't rehash all the overt acts because there is some overlap with the count 3 conspiracy to commit first-degree murder of J.J. Vallow. The first overt act we've already discussed, which is the evidence of those espoused religious beliefs justifying the homicide of J.J. Vallow. Number 2, we've already covered that the defendant's co-conspirator and then mistress, Lori, moved to Idaho with the children and with Alex Cox. Overt act number 3, the jury heard evidence that Alex Cox, the defendant's co-conspirator, took custody of J.J. Vallow. As to count or overt act number 4, that co-conspirator Lori Vallow provided false information to law enforcement regarding JJ's whereabouts. We did hear testimony of that as well. Number 5 and 6, again, those are also ones that we've already covered related to the financial issues. Count 4, the first-degree murder of J.J. Vallow. Again, we have ample evidence that a jury could use to reasonably conclude that the defendant is guilty of the murder of J.J. Vallow. In addition to the planning and preparation evidence that the jury would have heard related to the conspiracy that we've already covered, on September 23rd, the day after J.J. was last seen alive, witnesses testified at trial that they'd been staying with Lori Vallow and that Lori told them that they not only saw Alex Cox with JJ, but that Lori then told them on the morning of the 23rd that JJ was with Alex. And the jury heard evidence about what Alex was doing that day because he was en route to the vicinity of the defendant's residence, and he was texting with the defendant that morning. Also, the jury had heard that JJ, according to the defendant, JJ was dark. We just heard evidence of that this very morning when the defendant was describing in text messages to Lori that JJ wasn't himself and that he was possessed by some type of dark entity. And like Tylee, JJ's body was found in a grave on the defendant's property. Again, ample evidence from which a reasonable jury could conclude that the defendant is guilty of the murder of J.J. Vallow. As to count 5, the conspiracy to commit the first-degree murder of Tammy Daybell. Again, the state alleged a series of overt acts and presented evidence on every single one of them. The first one, the espousing of religious beliefs, similar to the other 2 conspiracy-related charges. Evidence was submitted on that. Number 2, again, we've already discussed that defendant's then mistress and co-conspirator Lori Vallow did move to Idaho to where the defendant lived, another overt act. Count 3, exchanging text messages regarding death percentages on July 30th. The jury did hear evidence of that. Overt acts 4 and 5, that the defendant and Alex Cox exchanged burner phones, that came into evidence as well. Overt act number 6, that the defendant's co-conspirator, Lori Vallow, exchanged texts regarding Tammy Daybell being possessed by dark spirits and being in limbo. The defendant and Lori Vallow were discussing that. And again, that evidence came in this very morning, Your Honor. Overt act number 7, that on September 8, the defendant signed an application along with Tammy to increase her life insurance policy to the maximum allowable under that policy. That came in via testimony and business records. Number 8, that the defendant's co-conspirator, Alex Cox, attempted to shoot Tammy Daybell. Evidence has been presented on that, Your Honor. Certainly, it's been a source of contention in this trial and a source of cross-examination, vigorous cross-examination, but ample evidence has been presented that that is exactly what occurred. Overt act number 9, that Alex Cox did multiple internet searches related to that shooting. Number 10, that Alex Cox went to the firing range in preparation for that attempted shooting. Number 11, that Alex Cox drove to from the Sportsman's Warehouse to the Daybell residence on the 9th of October of 2019. And number 12, that Alex Cox was near the Daybell residence on the 18th of October 2019 when Tammy Daybell died. All of that all of those overt acts, the jury heard evidence on, and it would be more than reasonable for them to conclude that the defendant engaged in a conspiracy to kill Tammy Daybell. On count 6, the actual first-degree murder of Tammy Daybell, in addition to all of the preparation evidence that the jury heard related to the conspiracy, the defendant was telling numerous people in his life that Tammy was going to die soon. The jury heard evidence of that. They heard evidence that the defendant would send text messages to his mistress and co-conspirator Lori Vallow regarding how trapped he felt, but how freedom was coming. The defendant's mistress, Lori Vallow, was shopping for wedding rings before Tammy even died. The defendant then told conflicting stories about how she died, when she died. At the defendant's funeral, Chad claimed that he had miraculously asked Tammy for all of her financial passwords just days before his death, or her death. After Tammy's death, Chad immediately moved out, cashed out Tammy's life insurance policy, and went to Hawaii to live with Lori Vallow, who he married just 2 weeks later. And of course, the jury heard evidence that Tammy Daybell's death was ultimately deemed homicide by asphyxia. Again, we have ample evidence from which a jury could conclude that the defendant is guilty of the murder of Tammy Daybell. As to the final 3 counts regarding the grand theft and the insurance fraud, there were pardon? Pardon? There was a clerical issue. Thank you, Your Honor. As the final 2 counts of insurance fraud, I won't belabor this since we've already discussed it in the conspiracy portion, but the evidence does show that the defendant and Lori began an affair in 2018. Months later, Lori's husband, Charles, was killed by Alex Cox. In the immediate aftermath of that killing, Lori and the defendant exchanged text messages where Lori expressed her disappointment that she was not actually the beneficiary of Charles Vallow's life insurance policy. Then months later, not even months later, mere weeks later, the defendant goes with Tammy to increase one of her life insurance policies to the maximum allowable. And shortly after that, Tammy is killed. The jury has business records, they have testimony, they have ample evidence from which they could conclude that the defendant has committed the crimes of insurance fraud as to both the Primerica and LifeMap insurance policies. Thank you, Your Honor.
All right, thank you for the argument. The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving J.J. Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows: the defendant, Chad Guy Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of J.J. Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that JJ Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date range that does not comport with the evidence. And I'm concerned about instructing jurors with evidence that I believe was never presented here at trial. It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29, point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given. In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond for the record.
Yes. Why don't you, I did say a lot there, and Mr. Pryor offered the state a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested. The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right, I'd note there's actually a rule that governs this directly. Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against. And if potentially one of these counts is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29, we've got our jury instruction number 4, which might be relevant on the on or about or on or between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and potentially ruling on this, including all the remaining counts as well. So we'll be in recess until 2:30 and we'll come back then.
All rise.
What? Oh. Oh my goodness. So we have to wait for 2 hours before they come back? Oh, what am I going to do for 2 hours? What is it? It's 12:30 now. So 12:30 their time. So 1:30, 2:30. So back at 2:30 for more of this. Here, it Linda will put in the chat what's going on. She's probably, did she put it in there? Let me see. Did she put any of this stuff in there? I don't know. Let me see. I'm sure Linda did, right? Linda, you've been putting this in, right? Yeah, she's been putting in. So she'll put in what happened and then we'll go. Yeah, Jen, I got it. I got the info. I got the info. Hold on a second, because we're gonna reread. I actually want to go ahead and open this up and refresh. Let me see. Are we up to date now? Oh, I'm gonna go back, grab from today. I'm like, what the heck? What's that? Chad Daybell said turned up. Was this? Oh yeah, I had to find the right date. Let's see where we're at with this. So the last time this, I think it just updated. So let's see. I'm going to go ahead and read what just took place, just so we have it. So get past this, but it has nothing further. Okay, so let me get to the right place. Okay, so we are back in the courtroom. Pryor will now argue for a directed verdict. Here, let me go ahead and put this up on the screen. Let's see what that looks like. Should be good. Let me see if last time I did this, it zapped me with some weird thing that made me think my computer was being hijacked. It came from an ad on the page. It's not the page's fault. It's, these things. So I'll put it on, see if that helps. What does that look like? Okay, we'll go with that. All right. So the directed verdict, which we know is a ruling from the judge after determining that there is no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. Pryor says there is no indication that Chad was present in the murders of JJ and Tylee. That's what we know that he's been pushing this entire time, and why prosecution has been really focused in on when they mentioned it in some of the testimony about, well, it could have been two people, especially lifting Tammy onto the bed, that kind of thing. So Pryor says in regards to the conspiracy charges, there is no indication that Chad was involved. For the fraud charge, Pryor says the only testimony he heard was the insurance was raised. At this quote, at this point, I don't think the state has met its burden regarding the fraud, all of the conspiracy charges, and they have not met their burden in the murders. Ingrid Beatty argues the jury should determine the weight of the evidence. She lists out the charges and says the state has presented evidence on all aspects of the charges. Beatty lists out the evidence the state presented in relation to each charge. She mentions the overt acts related to the charges. So here are the charges. Let me hide that. Sorry. Get some of this stuff out of the way. The three charges. You got 3 counts of first-degree murder, Tammy Daybell, J.J. Vallow, Tylee Ryan. 3 counts of conspiracy to commit murder, Tammy Daybell, J.J. Vallow, Tylee Ryan. Grand theft, and insurance fraud. He says there is ample evidence of the murders of Tylee and JJ because the bodies were found buried on Chad's property. A reminder of the charges Chad is facing, which I just read. Beatty mentions that Chad told numerous people in his life that Tammy was going to die, starting from 2016. Chad sent text to his mistress that he felt trapped. Lori was shopping for wedding rings before Tammy died. Chad told conflicting stories about Tammy died at her funeral, about conflicting stories about Tammy. I think that must be how Tammy died. Chad said he had miraculously asked Tammy for all the financial passwords just days before her death. Boyce is prepared to make a ruling, but says he has an issue with part of the indictment. The indictment was amended on February 20th, 2024, and says J.J. Vallow was killed September 8th or 9th, 2019. Boyce says J.J. Vallow was clearly alive on those days. Boyce says the language varies on the indictment. Yay! I just see, hold on. I just saw something pop up. Hold on. I'm reading. Hold on. Yay, Mia. Welcome to membership. Yay. Thank you. Okay. Thank you. Okay, where did there it is right there. Boyce says okay. Boyce says the language varies on the indictment from quote on or about and quote on or between. On the J.J. Vallow murder, it says quote on or between September 8th or 9th. Prosecutors asked to come back on Monday morning and argue. Pryor says the state has had plenty of time to change the indictment and they had already amended it. He doesn't think they should be able to amend it any further. Boyce says there is a filed amended indictment that has the wrong dates for J.J. Vallow's death. He's giving the state 2 hours to prepare for argument. So we will be back at 2:30. And that is where we stand. So for the next 2 hours, we got to figure out what we're going to be doing. Let me, where'd it go? Trying to find, where'd it go? Hold on a second. Is this it? No, that's not it. I lost oh, there it is. Duh. Okay. I lost that page. I got too many pages open under one browser because I'm trying not to look elsewhere and annoy people with me looking up at the sky. So I'll go back and see what you guys are saying. We'll be back at 2. Yeah, ended there. I have a writer, so no problem. So the indictment says that JJ was killed was clearly alive on that day. Okay. Oh yeah. Those things can be a problem. I've seen judges go back and forth and back and forth. I've seen them stop like reading jury instructions. I've seen judges stop everything, go make amendments, reprint them out, redistribute them, and then go back to reading. I've seen it done. I think it's okay to, some judges will just say, okay, we need to make, and they'll make a note of what needs to be changed, and then it will be changed after. And he'll put that on the record too, so that I'm making a note, this needs to be changed. On the final copy that will go to the jury during deliberations, that kind of thing. And again, I'm scrolled back. I'm kind of catching up with comments. And again, thank you. Christy says, am I the only one that hears reading and you get so engaged it starts to lull you to sleep? Not that it's boring, but so relaxing. I try to, if you're talking about when I'm reading that, I apologize. I try to keep it like I'm reading a story, or, like when it's somebody's words and they're saying it, I try to read it in their words. just so it's not boring. Oh. Okay, so back down here. Defense can't get away with the fact that the children being buried in his backyard, especially before Tammy died. Just saying. Do you think that they're they're trying to say that he didn't know that his property was being used, and that I gotta get this on my ear. Actually, I don't need it. I'll leave one in there. Okay, so do you think that they're going to try and say that, oh, he didn't know anybody was doing anything on his property? But that doesn't fit along with when Lori was on her way to Hawaii, and Zulema asked, or whoever it was asked, I think it was Zulu, Zulizi, I don't know however she pronounces her name, that when she asked if Alex was going too, and she said no, Alex is staying behind to help Chad with whatever the quote was. Jinlo, yep, that's what I use. Stream, ooh, come on, click, there we go. StreamYard is the software that I use, or to do this with, to bring in the stuff so y'all can watch it. Streamlabs is a bot, like Nightbot. Maybe Streamlabs has the same type of thing that StreamYard is, but this is StreamYard. I've thought about trying other things. There's also something called Restream. But I'm paying for this one annually, so I'm using it, and I'm trying to keep my costs down until my channel actually starts, getting better and stuff. It's a tiny itty bitty channel. Jinlo, I was just thinking it might be cool to have you all call in to talk to Addi in these big breaks. Oh. Oh. Yes. At least I didn't say Zaluma. I mean, how many times has Pryor said Zaluma? I don't know if I could carry a call in. They do have a thing where you could, like, if you go, if people wanted to come up and ask questions, there's a thing on here that I've never used, but I wanted to try it. Let me look at the thing. It is, let me shut that down. Okay, so there's this thing. It says start a Q&A. I kind of wanted to test it out and see what happens. I've seen it for quite a while on here in this YouTube studio thing, and I wanted to see what would happen or how it works. I kind of want to do it, but I don't want to mess anything up. If something messes up, we can stop the stream and restart it. I'd rather not, but I'm gonna click on it and see what happens. Okay. It says say something. Start a Q&A. Okay. I want to see what happens. We're going to test it. Let's be testers to this Q&A thing and see what it does. I'm going to type something that says say something. So what should I say in it? I want to test. This is a test. This is only a test. The National Broadcasting. What? Oh, so let's say something. I don't know what to say. My brain just shut down. I kind of want to test it out, but I don't know what to say. So he can't because Chad's cell pinged outside with Alex's cell. Did they get on those pings? They did for sure show that their cells pinged together on the property at the same time. I don't recall seeing that. Yeah. Okay. I'm going to see. Oh, yeah. Let me see that. I'll do that one. Oh, wait. I'm going to ask something first. Okay, here we go. I'm going to start it and see what happens. And then let's see. I have absolutely no idea what this is going to do. Ooh. Questions list. See viewer questions and choose which ones to answer. Oh. Oh, so then it goes into here and then you guys click on, I guess you guys click on that. I'm going to try it. I'm going to test it myself and see what happens. No, I guess I can't answer the question, but let me see. I'm going to see what happens. We're going to see what happens. So let me know if y'all can get that to work. We're going to test this out. Why not? We're bored. Sorry. Our numbers are dropping. Addie's being boring. I just want to see what happens. And there's no better time to test it out than now, right? So I think you're supposed to click on that, right? Oh, let's see. I see questions already. So answers. So my question is, are you for or against the see, I asked you guys a question. I think you're supposed to ask me the questions. But whatever. That would have been a better poll than a question. Right? Because I think you're supposed to ask me questions in there. Is supposed to how that works. The other that would be more of a poll thing. So I confused it with a poll. Let me see if I can find where to. So there. So Stevie did one. She did here. He did a question. So you can ignore what it says and just, and then I can do this kind of thing. Oh, so then I see the actual questions. When I click on this, it shows me only the questions. Okay, so now I'm seeing questions. Let me see what happens if I go in here. Oh, so I have to look at it through. Okay, yeah. Hold on one second. Let me go back to what I was looking at. So I'd have to go into here and look at it like y'all. Let me see. Maybe it's this one. Okay. So like here's a here I don't think I can put those tests. Does Addi rock? Oh no, yes, she does. So I'm gonna select this one, and what does it do? Test. Oh, so it puts it up there. So now you guys see it there, and it doesn't go. Let me see what happens in StreamYard. So StreamYard doesn't put it where I can pin it to the screen, which is fine. So it just basically works through YouTube Studios, but it doesn't put it in because you're not doing it through StreamYard. Aha, got it. Okay, so we're learning something. And numbers are probably dropping. Sorry, y'all. Okay, so then you would do another one like this. Select question, and it gets pinned up there. Why should society pay his expenses for life? Ooh, that one I like. I'm going to tell you something that most people don't know. In most states, it is more expensive for the death penalty is more expensive for taxpayers than if an inmate actually or a convicted person stays in prison for life. It's cheaper to house them for the taxpayers than it is for the death penalty, because you have the cost of it depends on how they do it. You have the cost of whatever it is they use to do it. You have all of the appeals process. You have all of the court stuff, all of the stuff that happens before a person is eventually put to death. And because of that, it's cheaper to house them in a prison than it is to put them to death. So, like, I'll go back over here, and then I would see what you guys. So, you guys are cute. Anyway, but most people don't realize that it's actually more expensive for the death penalty, and it also can take longer. I mean, there are people still on death row that have been on death row for a very long time. That'd be something kind of neat to Google and see who is the longest person on death row right now. There are people who've been on for quite some time. Let's see. Next question. I have to find it. No, look over here. Okay. Oh, no. Okay, look. Do you feel like they've successfully made the insurance fraud claim? Okay, so I actually I think that they put enough testimony out back and forth between when he went to have things changed, when the deaths happened, and that he was utilizing that after the fact too. Like, I think that well, let me think though. So let's look at that real quick. Let's see, what is the insurance fraud about? I'm gonna type in Chad Daybell and insurance fraud. No, okay. Okay, let's see what we get. Trying to see what we got. So I assume that expert. So would the fraud be because I'm trying to think of how. Let me see. I'm gonna pull up one of these and see if I can. Fired. I had it. Where is it? Commit. Let's see. about insurance. Okay, so Chad Daybell is charged with murdering Joshua plus his wife Tammy, and is facing the 2 kids and police detective. Okay, it says a Rexburg police detective and an FBI forensic accountant took the stand, laying down almost identical bank paper trails and timelines showing Vallow Daybell swindled Social Security benefits that were meant for JJ and Tylee after they were murdered. So that's it right there. So if that's the case, if it's for JJ and Tylee, then wouldn't that be for is it Social Security? Is that insurance fraud? Yeah, Social Security, yes. The prosecution questioned additional evidence regarding Daybell possibly linking him to the crime of conspiracy to commit murder and grand theft. Okay, that's that part. Okay, so collecting Social Security, here, I'll share this, make it bigger. So y'all can see what I'm looking at. Maybe after this, let's see. Oop. Oop. Okay. The first of the 2 witnesses to take the stand Wednesday were Detective Sergeant Chuck Consitis with the Investigations Division. Prosecutor Rob Wood spent the whole morning admitting numerous documents into evidence, sifting through financial statements and bank transactions for Vallow Daybell, Tylee, Alex Cox, and Daybell. Most of the focus stayed on Tylee and Vallow Daybell's financial paper trails. The court also dug into text messages, emails, and travel itineraries connected to Daybell. Consitis originally investigated JJ and Tylee's disappearance in 2019 and explained what he discovered as he tried to locate the children. Going through Tylee's financial history before and after she went missing, he said they found Vallow Daybell switched the direct deposit of Tylee's Social Security benefits from Tylee's account to follow Daybell's own bank account and began collecting orders. Was there anything significant about that? Now, is this for which trial? I hope this is for the right trial. I didn't, but I think that they laid out enough evidence to say, yes, that they conspired together. He conspired with her, conspired to commit the fraud, and it's all encompassing. He was on board with it all. So I would say yes to that question. It will be interesting to see what defense has to say when in their case about that part, because they have to go through each one of these and present a case to put in those the mitigators and all that stuff in front of the jury. If they can, what are they going to come up with? What are they going to say? That Chad didn't have anything to do with it? We've seen all the testimony and stuff. We've seen the conversations about the insurance, that they were upset that it didn't go through, and he conspired. Does this also link him to Charles as well? Because he knew she was upset that certain things didn't go through. How far does it connect him to all this stuff? So she conspired for sure. She did everything she could to make sure that she was getting money from any insurance she could come up with, and he was on board with it. So that's kind of where I see that. I want to see what y'all are. Let me go over here. I'll put this back here to live chat so I can see your responses as I'm saying all this. So do you guys agree with what I'm saying, or have I lost my mind on that? But if to answer that question, yes, I think that they have put in significant amount. I mean, they have been so thorough. The way they've produced and put the test or the evidence together to really draw the jury in. I don't think there's any way the jury wasn't able to follow all of it, of the paper trail. Just my opinion, which forgot to do something. I forgot to change the banner out because they're not doing that. And y'all can, if we get any new people, you can let them know what's going on and what we're waiting for. Let me see here. So, I mean, Lori was collecting money from the state, I believe. Yes, she was collecting on both the kids, on all of it, and he knew all of that. So in this case, is he connected to it enough to warrant? What would be his insurance fraud? That would be his part of the insurance fraud would be to conspire with her, because he got Tammy to up her life insurance like how many days prior to her death? So I kind of say yes. Okay. Did I answer that sufficiently? Or do I sound like a doof? Okay. So ask, what do you feed? Oh, what do I feed my canines? Fresh pet? We feed them fresh pet. If a tree falls, if a tree falls in the forest and no one is around to hear it, does it make a sound? Ask the animals. Jen asks, will Chad ever get to see Lori again or talk to her? I don't think so. I think he knew he wasn't coming home, and he probably won't ever get to talk to her. I would assume that if there's two of you and you're both accused of the same thing, that you cannot have contact with each other. You can't be calling the jail back and forth. So I would say no. Maria asks, do you feel like they've successfully made their... Oh, I already did that one. Sorry. I already did that one. Tree falls. Dana says, can pandas be brown and white instead of black and white? I think so. Right? I've seen... Let me see. I have to Google. Let's see. Guess what? Either they messed up the color, or this little panda bear that I'm looking at has here, I'll show you. So either the panda was out in the sun too long and he faded, or yes, you could have brown pandas. Okay, let's see. I'll go back to, I'll make sure the quart's up so we can see it. But I keep losing where I put it. There it is. Go back to that. Go back here. This is kind of fun. I don't know. Is it boring? Am I losing? Oh yeah, I'm losing chatters. They're like, oh, good Lord. What is this woman doing? Okay, so do you think... Oh, why isn't it letting me... Oh, select question. There it is. Do you think, Dana, do you think Chad will be found guilty? Oh, absolutely. Yeah. I've been off the fence on this one for.
What do you call a dragon with heartburn?
Ah!
Bad news for the nearest village.
Did you guys hear that? That was my Alexa. She just told a joke. And something about, what is it? What did she say? Butterflies? I don't know if you could hear that. Maybe not. All of a sudden, Alexa chimed in. And now she's like, okay, fine, you're talking about me. Oh, yeah, don't mention her name. Let's see. So I think we got down to the bottom. Oh, wait, here's another one. Maria asked, do you think Melanie B. Boudreaux, I had to remember which one she was. Let's look at that again. Would have offered her children up to be unalived if they had been declared dark? Wow, that is a fantastic question. I struggled with Melanie and her ability to buy hook, line, and sinker. However, personally, no, I don't. I think that she kind of started to see that what was happening was falling outside of the reality. Like what she had, I feel like she was realizing that what was happening, they're saying, this is what happens to the kids. You know what I mean? I don't think she would have offered up her kids. And I definitely know that Brandon wasn't going to let that happen. So, but I don't, what do you guys think? Do you guys think that she did? I don't. I think that she would have eventually, on her own, without Brandon interfering, realized that what was going on was over the top. So y'all let me know what you think on that. What are your thoughts? Do you think that she would have? And then what does it say? I have to select it because I can't see it. Jen asks, can they get divorced? Oh, yeah, I assume they can. Will they? I bet you they won't. It'll be interesting to find out. I would assume they can. Oh, let's see. What does Google have to say about that? Let's see. Oh, the AI doesn't want to answer that. So I've been using that AI thing that's on here, and AI is like, yeah, I'm not going to answer that one. So, but I would assume, I mean, don't you think that they could get divorced if they so choose? Hey, Bodie, we're doing a practice question and answer session on this YouTube thing. I just wanted to see how it worked. I've never used it. I saw it sitting here, and so let's see this question from Jinlo. Why do you think they didn't find Melanie Gibb was not found liable for something? Because she bailed early enough. I was always wondering why she was never charged. I mean, we know that without immunity, who is it? Melanie B. And who else has immunity? There's people Zulema has immunity. I think that because she dipped out early, and she contacted them or the police, and that was she given immunity? I don't think she was given immunity, but she went to the police and told them that she'd lied. And I was surprised, no prosecution on that, or getting her for lying to the police. But I never really understood why she was never charged. I think she should have been. For a long time, I felt like she knew more than she was putting out there, that she was copping to. Thoughts, you guys? What do you think? So, like, here, let me look over here real quick in the live chat. So Dana says, for Melanie B, it was in her new husband that helped her question it all, same as the Melanie Gibb. David Warwick made her question it all. Yes, right. But without the help of the spouses, would those two have gone the full length of this and be sitting where Chad and Lori are currently sitting? That is a part that for both of them, I don't think they have the same issues that Chad and Lori have. I think they both realized, something's not adding up here, and they bailed. I'm surprised they didn't go to the authorities sooner, though. They held on to it and I guess until they were questioned by the police. And then, like Zulema, we saw her interview with the police, and but they were given immunity to divulge what they knew, or what they had witnessed and stuff like that. Like Jen says, she thinks Melanie Gibb wouldn't. And I kind of absolutely agree with that, because she bailed. She was out before any of them. And so what I think Gibb wouldn't. See, yeah, I think so too. And what Dana said here about this for Melanie B, it was her husband that helped her question. Right. But Dana, do you think that on her own without her husband, do you think she would have stayed in it and give that question that was asked? Would she have given up her kids? I don't, because I don't want to think that. I think she was naive and she was believing it until it got to a certain point, and it just so happened that Brandon helped her, or it helped her come to realize that there's something wrong. I don't know. Maybe I'm not answering that right. Oh, let me see. Go back here. Any more questions? Did we get them all? Here's another one. Do you think why do you think they yeah, got that one here. Let me select this one. Yeah, if I were going to do this, I'd have to have two things open because the back and forth takes forever. So Jinlo asks, do you think that Chad's kids will ever see that Chad was involved in Tammy's death? Not until after, if they ever get the chance to watch the trial. But then again, as a child of a parent who is being accused of this, would they? I think if they saw the evidence, I think they would. But they have to be willing to accept it, that it is a thing. But I think they are so ingrained and so brainwashed by him that it is going to be a struggle for them after this. I would like to know to what's going to happen to them after all this, as they progress in life and where they sit, even religion wise. But I think that they are going to struggle big time accepting this in the long term. So Jinlo said about the whole, she thinks that without the help of the husband, it would be doubtful. And then Jinlo, that's for the question that's up there now, that she was so manipulated. Melanie. Yes, Melanie. I mean, Melanie. There's too many Melanies in this and I get confused. And then Candy says, if they haven't by now, I don't think they will. Exactly. I think that they are going to be always thinking, it's all Lori. They're going to think this is all Lori and Alex. They're going to put it off on her, and they're not going to ever be able to accept that their father was involved in this. Dana says, I agree, Jinlo. I think both Mels would have went farther if neither had David and Brandon knew her. Her new husband, just not sure how far. See, that's where I'm sitting. I don't want to think they would. I want to think that no, they would have figured out, hey, something's not right with this. Something's not right with this. And Dana agrees, but we won't know now. We won't know the answer to that really. But in my opinion, I like to think that they wouldn't, that they would have not put up their kid. They would have bowed out on their own, because I'm a wishful thinker. Okay. And Jen asks, is Pryor still the owner of the house? Are the kids still living there? Yes. Pryor and whoever else are on the deed of the house, and the kids are paying him rent. And that is how this trial is being paid for. The kids basically are paying for it with their rent. So yes to that. This is actually kind of neat. So what are your thoughts about that? What do you think? What are your thoughts on Pryor owning the house? Part ownership and receiving the rent. I don't have a problem with it, because at least he's getting paid, right? Maybe. So Candy says, unfortunately, he's their dad, and they, in my opinion, would want to believe that he wouldn't do that to their mother or to them. Yes. So there you go. And that's where I sit with the kids. I think that they will never accept this. But Dana says, as to Chad's kids, I don't know if any of them was in the gallery and listened to the evidence and how involved Chad was. If they had, I think maybe Emma is questioning stuff, if not in the gallery. I don't know. I don't know. I think that if you're family of victim, I think you're allowed in the gallery. So I don't think Chad's kids are permitted in the gallery because they're not family of victim. Does that sound right? Is that from what we realize when that's a subject that has come up before from Boyce? They've talked about that. Lemon says, I think Pryor was well aware that there were stairs in his new property. Yes, for some reason, and I still don't understand. Maybe he'll bring it up in his case. Maybe he'll touch on it and we'll figure out why he was denying or trying to say that there were no stairs. I don't understand that. There were clearly stairs, even if it's the add-on and it's to get to the attic, it's still stairs. But so I don't know. Maria says Pryor needs to get paid. I don't think he believes Chad is innocent. I agree with that. Yes, I have no issue with him. He has to be paid. And that was the source that they came up with, and I don't have an issue with it. Stephanie McCall, I think that it's really shady of Pryor to try and get off the case knowing that he's been paid in the property. I don't know how to feel about that. His reason for wanting off the case, what was his reason? Do you guys remember what he stated was his reason for it? Other than he's not death qualified? He is a private attorney, so he doesn't have to be death qualified. Tammy's victim though, right? Tammy's victim. So, oh shoot, yes. Yes, thank you. That's the connection. So they could have been in court. Sorry about that. Sorry, brain. I was thinking, that's right. So yes, then if they have a family victim, then they can be in the court. But I have not heard this entire trial that his kids were in court. Have we heard that? Has Nate or anyone said that you guys watch, or, over the last 24 and a half days that they were in court? Thank you for reminding me of that. Sorry, Tammy. I didn't mean to neglect you. Tammy was a victim. Yes. Thank you so much. Duh. She's their mother. So technically yes. No, she is a victim. Yes. That's the part that I forgot to connect that part. This is a case where a parent possibly is accused, not possibly, well, allegedly accused of murdering another parent. So I forgot to connect that part. Sorry about that. Candy says, I don't know how they could live on that property knowing that those sweet babies were buried there. I personally couldn't do it. I would bet you anything that after this case ends, that Pryor does something with that property. I wouldn't be surprised. I wouldn't be surprised if they either sells it or something happens to the property. And Stephanie says, as far as I remember, it's just the death penalty qualified situation. Oh, I know, Candy. There's yes, absolutely. Barry Morphew, Macy, and Mallory were Suzanne's daughters. They both were in court. Yes. Yeah. I didn't mean to leave the kids out. I just, in my brain, that doesn't always make connections. And then we're in a case where we have a parent who's, allegedly accused of taking the life of another parent, that in my head, when I'm saying that, when I'm looking at what the rule is from the judge, I forgot to connect that part. So, oops. I am not a lawyer for a reason. Maria says, I'm only aware of Chad's brother sitting in to watch. Other than, Chad's brother. Yes, Matt was there because he was over talking more to Kay and Larry Woodcock, JJ's grandparents. Candy, they will be out of there so fast he won't have a need for it or them. So let's see what's going on over here. And the last question is from Jen. What has been everyone's favorite case so far this year? Let's see. You guys put it in chat and let me know. So I started off the year. What did I start off with? At the beginning of the year, we started off with YSL. which I have no idea what's been going on with that at all. I have no idea if it even ended. I have seen no news and have not looked for it, so I have no idea. Is that case still going on? So far for me, it's this one. So, all right, let's see what time it is. Oh my goodness. We got evil YSL. Oh, what a case. So looking over here, I do need to get up though and move my body for a bit because so it's 1:30. So what time? They said 2:30 back, right? Let me I want to pin a comment. No, I want to put it up on the screen. Where is it? I'm looking for the one Linda put in the chat. They said 2:30 back, I think. Yeah, let me grab it from Twitter. So, okay, let me refresh. All right, so where is it? 17 minutes ago. Oh, an hour ago. An hour. I don't see it. Where is it? State res. Okay, got that one. Big says, wait, get off there. So Linda, or some, let me see. Did y'all put it in the chat? And I'll pin it to the thingamabobber. They said 2:30, I think, back. But I don't want to misquote. Yeah, 2:30 return. That's what I thought. Okay, let me put it up. Let me get my banner. Okay, let me edit this one. And we'll put that there. There you go. I'll put it there. All right. So, okay, let me end this question answer. I think we're done. Okay, yeah. What did y'all? Oh wait, I gotta see what y'all said about that. Did y'all answer that question that Linda put up there? So Candy says there have been so many. There has been so many. The YSL trial is absolutely insane. Almost 80 days for them. Wait, they're still going? Holy mackerel! Boy, did I. Oh, poor. Oh my gosh, those poor jury. 80 days. Yikes. That's almost 3 months. I had to think about it. Right? Almost 3 months. Think the Darrell Brooks trial was Dana's favorite. That is it bad to say the trial itself was not fun. I don't mean to say that, but I did enjoy the chat during that one. You know, because in that one, I stressed right away that I was not on the fence at all, as were most people when we were watching that trial. And so therefore, I was freer to be like we are in this trial on my channel, where I can have my opinion and it be okay. So, but yes, Darrell Brooks was a very interesting trial. And boy, did people want to say she's coddling him too much. No, she's trying not to have appeals. That was I bet that was a hard trial for her. And Jen says she liked Anderson. Okay. Yes, right here. YSL started in November. And this, oh yes, this one, I don't really want to go into much about my part in it, but this was a fun one. And I hate to say that about a trial, but for me, because of the way I was running it at the time I was running it, I loved it. There were 3 camera options and I was working between all 3 and putting them up and really listening and knowing when to go and when to do yada yada and do all the things. For me, technically, that was my favorite trial. And I also thought it was an excellent trial, the trial itself. But I was so caught up in the technical aspect of what I was doing and stuff. That's as far as I want to go with that. But because of that, I really enjoyed the trial. And Linda says she liked Charlie Adelson. Candy says, let me end make sure that I've got the question and answer thing. Yeah. So we'll end. I think this is how you do it. Yep. I think, okay. We'll end. So we'll remove all questions. Oh, well, okay, cancel. Hold on. We'll, I don't, if I do that, then, oh wait, no, it's okay. Oh, I see. So when you end it, it poofs the questions or in that thing. Wait, let me see. We're going to test this. This is another part that I have to test because this is the first time I've done it. So this is the first time I've closed out the Q&A. And what did it do? Yeah, it did. Oh, well, whatever. So basically what happens once you end the Q&A, all of those questions get removed. So then you don't see the questions anymore for the replay people. Well, that stinks. I don't like that part of it. Okay, YouTube, if you're listening, that part really isn't good for those of us who have our lives and want to keep those questions up where people can see them, because that stinks. Now, when people listen to this, they're going to be going, where are those questions? I don't see those questions. Sorry, once you close the Q&A on the YouTube studio, the questions are deleted. So now we know. Hey, trial by error. Yeah, see? The question was taken off the screen. Yeah, and so were all of the questions that were asked. They were also removed because I've not seen any of them. I don't think. Let me see. Right? Maybe it didn't. Let me see. Totally understand. Yeah, I'm not seeing them. I think the question was taken out. Yeah. So I think it does. I think it removes. So I think so. I'll have to go back and look. But that was an interesting experiment to see how that worked. Maybe so. I hope so. I don't know. Oh wait, Dana, Timothy Ferreter was so shocked he didn't want to spend time in prison. He wanted home confinement because he didn't think what he did was serious enough to warrant what happened with his sentence, in my opinion. And then maybe maybe, I don't know. That trial. So, during that trial, during the Ferreter trial, here, I'll keep this up for a second. During the Ferreter trial, there was a request from the judge that all names in that trial be redacted from any live streams. So I spent the entire trial editing out every time the kids' names were mentioned. That was one of the hardest editing jobs that I have ever done. I did it all. I think I did the entire trial. I think so. There may have been the very last part where it got to be so much that I was given permission to not have to do it. But I think for all but the very tail end of it, I edited every bit of it. Think about that. That's an 8-hour a day trial, 7, 8, whatever it was, more or less, I was exhausted during that trial. That one wore me out. And it wasn't even like today's stress during trying to get those things so you guys could see it better. That was more me trying to go quick, trying to be quick. And so there was all my facial expressions up in the thing. If anybody missed that part during the last part of Edward's testimony, there were 36 exhibits, screenshots, whatever, that were put up on the screen, and I was making them bigger and putting them up so everybody could see it better on the screen. So I would have to go take a screenshot, put it in my fancy schmancy editor thingy, edit it, download it, upload it, and then stick it on the screen. And I was flying, and I forgot to turn off my camera. And so there was a lot of facial expressions probably, which I am not going to go back and look. I will just ignore it. I'm actually going to skip past that when I add the timestamps in, because I do not want to see it, because I know it's going to be bad. I was going, ooh, I could tell. I was all up in my stress stuff I do when with autism. There's certain things that you get really, and in fact, I the only reason I knew it was happening was because Brian says, "Are you all right, Eddie?" And I'm like, "Oh crap! I forgot to turn the camera off." Oh well, it is what it is. But you know what? That's a part of life, and it's a part of what I deal with. And most people who are on the spectrum do the same thing. And yes, I brought up autism again. Oh, but let's see. Oh, Candy's responding to Dana about the Timothy Ferreter thingy. She says it was too funny, like that was going to happen. I don't even remember if I remember what his reaction was. I think he just sat. Oh wait, yes I do. He sat there with no expression, right? He was completely dumbfounded and was just sitting there, right? Isn't that what was taking place with Ferreter? And then Dana says, "Oh, and he said he would do it again." Geez, Tim didn't learn anything. He doesn't think that he did anything wrong. He thinks his way of punishing his kids, that he was doing it for their benefit, and he's a punisher, and he was okay with it. That was another trial that I struggled with too, because I have issues with the whole corporal punishment on kids thing. I do not agree with it. And that's as far as I'm going with that. But yeah. And Jen says that's crazy. Yeah, it was a lot. I mean, I had to run. So we listened to the entire trial. So while the trial was going and while it was running, I was editing the day prior. So I was trying to make sure that I was getting through it, and I had to go normal speed to get through it, because even though the judge kept asking them not to say the names and just use the initials, neither side, the judge, in my opinion, was the only one doing that. So whenever it was his part, I knew I was okay, because most of the motions and arguments and all that stuff were pretty much name free. The only time that the names were really used was during testimony, and mostly by the defense. They kept insisting on using the names, even though they were asked repeatedly not to. And it was the most frustrating thing. And I had to listen to it in real time, because you don't know when they're going to say it. And if you're listening to it sped up, you may miss it. So, yes. So I was a day behind everybody. While y'all were watching it live, I was watching it a day behind, until I finally got the okay to not have to do that anymore. So Candy says they were so high and mighty, or so they thought they were. Can't wait for her trial. Do you feel that she was just as bad as he was, or do you think she was a little bit more lenient, or do you think she was different in her what I consider corporal punishment? I think the stuff that he was doing was way worse because first off he was angry with it too. There was a lot of it was a lot. But do you think that she was just as culpable, just as bad? So let's see. Jen Lowe says Nate said that if Chad ends up in jail, he has to stay in solitary for 23 hours of the day, 1 hour out of the cell. I wonder how he'll deal with that. He will live in his own world. He will be all up in portals. And he'll be communicating with whatever it is he's communicating now in his portals. And I wonder if sometimes his head will be in the portal potty, trying to communicate with whatever it is he's communicating now. I still think that is the funniest thing. I got that from Nate's chat I still say it. I think it was somebody named Paul Sorensen called it the portal potty. So Candy says, yes, he was just as bad. Jen says, she was just as bad. Sorry. Jen says she was just as bad. Candy says, there is no way in heck I would allow my husband to do that to a child of mine, even adopted, never. He would have to answer to me if he did. Yes, absolutely. We made the decision early on that we were going to use better methods, and we didn't use corporal punishment ever. You can raise good kids and use things like timeouts and stuff and get them through, and they end up really well. They do really well. We used the super nanny. She worked very well for our son, and by the time he was a certain age, he acclimated to it, and kids will they learn quite well. You don't have to do that kind of stuff. Jin Lo says he'll live in his prison portal. Yep. That's what I think he's going to do. He'll just be in his own little world. He'll probably write books on the wall. I don't know in solitary confinement what kind of stuff they get. Like what can they have access to? I don't know. So gosh, that just it gives me a horrible feeling of thinking of being confined or even alone that long every day. Oof. Yeah, we used to use timeouts a lot or loss of privileges. We never really had to do the loss of privileges thing. Timeouts worked well. The super nanny thing where you sit them in a naughty chair for 1 minute for each year of, however old they are, and you don't speak to them. You just put them in the place and you don't use your voice. It worked really well. And it got to the point where we then learned to look at the good behaviors and ignore the bad behaviors, and that worked too. So you can raise kids without corporal punishment. Ferreter case was a very hard case. So Jen Lo puts, and this is in regards to confinement. So furniture, a cot, toilet, sink, and sometimes a small desk lighting. Lights are on from 6 a.m. until 11:30 p.m., leaving about 6 hours of darkness. Iron door with an opening at the bottom for guards. Is this from the jail he'll be in, Jen? for the guards, bottom of the guards to insert food, and then a window, a narrow slit for a window, one of which may face the hallway. Ugh. Outdoor time. Federal appeals courts have ruled that prisoners in solitary are entitled to outdoor time. Exercise in an exercise room or a fenced or walled, quote, dog run. Leisure books. Same inmates may be allowed up to 3 leisure books in their cell. Okay. So they don't get, so no writing things. They can't write. They don't get, as I remember, they wouldn't let Jodi Arias have anything but a golf pin, what everybody called the court pencil. Pencil of the court is actually a Twitter name that's been around for a very long time, and it came from that trial. And then solitary confinement can also include, okay, here we go, limited contact with others, infrequent phone calls, rare non-contact family visits, limited access to educational programming, limited reading material, limited personal property, physical torture. What? These are common ones used in solitary. Oh, wait. That last part was probably not supposed to be what we should have put in. Physical torture. This is talking about a kind of, what kind of confinement is that? Well, that's not the same as where that's a different kind of confinement. Infrequent phone calls and rare non-contact family visits, extremely limited access to rehabilitative or educational programming. The itty bitty pencil, yeah. Because she was doing court art. Jodi Arias did court art. Like, sorry, Jen. I was like, what? Physical torture? Oh, and demonetized. I should check and see. Speaking of that, let's see what's happening with this poor little with my channel. Have I messed it up so far? Let's see. It should be good. I haven't said anything much. Nope. All's good. Awesome. Very good. Okay, so we're at almost 40 minutes until they're supposed to be back, more or less. Dana says, well, Chad and Lori won't be having conjugational visits. They will have to use their imagination, which they've been doing that a lot. They did that a lot anyway. Oh. No, I just thought it was funny. I got to that last part and I'm like, what? But yeah. So Jen says, it is commonly understood that physical isolation of individuals who are confined to their cells for 22 to 24 hours a day, allowed only minimal meaningful contact. Yeah, I don't like the thought of that at all. So, well, what I'm going to do right now is I'm going to play some stuff from yesterday. I'll see if I can find something and put it up for a bit so that I can take a break. I think I had something. What is it? This one? Yes. Let's see. So, from yesterday's testimony. Yes, yesterday's testimony. I can play. How long was that phone call? I could play the phone call. Do you want to listen to the phone call for a little bit? Well, we still have. I'll start with the phone call, and then we can listen to some other stuff. But here, I'll play the phone call that was from yesterday.
But this jail phone call was recorded on June 8th of 20.
The content in which you're about to hear, what they were talking about and who they were referencing, stuck out to us. Yes.
And
Oh, wait, let me fix it. Hold on.
we spoke about that this jail phone call was recorded on June 8th of 2020. Do you recall an event that took place on June 9th of 2020?
Yes.
What happened that day?
That was when we served the search warrant on the Daybell property and found Tylee and JJ.
There, you could.
And so did you listen to this June 8th recording before or after June 9th?
It was after June 9th.
And Your Honor, if I may publish by HDMI.
You may.
And Judge, for purposes, I'm going to ask that the entire audio recording be published.
You intend to publish the whole call, Mr. Wood, or an excerpt?
Your Honor, I intended to start the call in at about 6 minutes. I think if Mr. Pryor wants to play the rest during cross, he's certainly welcome to.
Yeah, I would agree. You can publish an excerpt if you'd like, and the entire call has been admitted. And if you wish to play other sections not played by the prosecution, you can do that on cross.
And for the record, Your Honor, I am going to start at 6:10. Or 6:04. So that's where it's going to let me start.
Visions under pillars of fire. That's what you were reading to me.
Yeah.
Because at the very beginning,
If I can inquire, is that coming through the?
No, it's not.
and this was all still before the second coming, the Lord had ordained for us to begin the millennial day within Zion and her cities while war and chaos reigned everywhere else. So it was already like the millennium, they were already living millennial way
Like a pocket, yeah.
the whole time.
That's kind of how I've seen it, as begins with a family, then a neighborhood, then a town, then a city. And New Jerusalem's kind of the best example of that.
Right.
Yeah, it starts small, but grows exponentially. It's will, and they're doing all they can to destroy one of the key families, but they're not going to.
I mean, there's so much that I know. I was sitting here thinking about that. I know too much.
Yes.
I can't deny it. I know it's just a matter of time. I just don't know what that timing is.
So I texted Ray. He responded pretty quick.
Detective, I'm gonna pause it there. Did you hear Mr. Daybell say I texted Ray?
I did.
It's because my microphone wasn't up here. Yes, I can. Did you hear Mr. Daybell say that he texted Ray?
Yes, I did.
Through your investigation, did you become aware of any individual that had a nickname or alias of Ray?
Through our investigation, we learned that Alex Cox often went by Ray Lamar. We also associated a Gmail account through phone records back to Alex Cox, and that Gmail was raylamar@gmail.com.
Now, what was the date of this phone call again?
June 8th of 2020.
And was Alex Cox alive or dead at this time?
No, he was deceased.
Do you recall when he died?
December 12th of 2019.
Detective, through your investigation, did you find any information that Chad Daybell claimed to have the ability to speak with people who were deceased?
Judge, I'm going to object relevance.
Overruled.
Through our investigation, interviews with multiple witnesses that were close to him, through the teachings in his books, he would often talk about how he had the ability to see and speak with people on the other side of the veil.
In your honor, I'm going to resume playing at 7:34.
All right, before you do that, Mr. Wood, I think we might be able to assist on the audio.
Your honor, I'm going to start playing at 7:34, and if the court can let me know if it's coming through the speakers.
All right, thank you.
Oh, that's good. Usually it's hard to get a hold of him. He's busy
Okay.
days.
Yes. But I asked him what we'd talked about. And he's very optimistic.
It was very optimistic for you, or he's very optimistic it could happen.
He's very optimistic for both of us.
He doesn't know his own project timeline.
He said, stick with it. To what he projected in that paper he wrote.
You know, house renovations always take longer than they think.
That's the problem.
I've been watching that Extreme Pools,
Uh-huh.
and the people are like 3 months out. Like,
I mean,
when they estimated they'd have it done, and they're like, we have so many problems, we couldn't get to the backyard, we had to pull a crane over the house to get these huge rocks for the waterfall.
I can remember last summer, Taylor Hill, Mark's friend, parents moved into a trailer, like a camping trailer in their driveway because they were going to build their house by the end of the year. Guess where they're still at?
Really?
They sold their house to their son. And it's just a weird situation, but you're exactly right. Yeah, it takes forever.
Yeah, there's always something comes up. Well, we didn't know when we dug in your backyard, we were gonna find whatever. And then they're like, we have to redo all the piping, and then we had trouble with this, and then something else happened. And so, but they try to make it sound like it wasn't really that long, but it's always like, gonna take 3 months. And then 3 months after that, they're like, okay, it took 6 months. You couldn't come in your backyard at all. And now it's not summer anymore. Now it's winter and your pool is finally done.
Right.
Mostly they do it in Florida, places like that. So he's optimistic about his construction problem, or construction
Problems.
not problems, but plan. His
Yeah,
construction plan, the blueprints are still intact.
yes.
They're tiny.
And I kind of just said, I texted him what you just said is, you guys are always a little off.
Right, exactly. We just want a real estimate.
Right.
What do
He
you say?
he just laughed. Did a
So
little-
he did not,
help him out.
he did not confirm nor deny that fact. That contractors are always
no,
later than they think they're gonna be.
He's like, it'll work out, how he is. He did want me to say he misses you. But he's not far from, contact. We can talk, we can text him whenever he wants.
Yeah, I can't text anybody. Have text.
It was,
Just text for me. That's like me telling you, I need you to tell this person, talk to this person.
I'll text him back. But he's optimistic. That's, I want to go visit him and grab him by the throat and say, really?
Can he? I know he's optimistic, but can he just make us any guarantees? I mean, we did make our down payments and everything else.
Guarantee.
It was like a guarantee, just an end date of our project.
Well, he knows you pretty well. So he just laughs. No, I asked him what he thought of the video project. He said it was really nice. He loved it.
Oh, good.
Detective, through your investigation, were you aware of any type of video put out about Alex Cox around this time?
Not around June 8th. But shortly after Alex Cox died, his sister Summer Shiflett made a YouTube video with clips of Alex, photos throughout his life, and put it to music. And so we viewed that early on in the investigation, but that's what is being referred to here.
Judge, I'm going to object. That calls for speculation. He can't speculate is what it calls for.
Untimely, overruled.
And Judge, I had stopped playing at 12:13. I'm gonna recommence playing at 12:13.
You may.
Yeah, oh, that's good. Although I'd never heard that song before. I don't know what that is. Maybe it's just something on like iMovie or something that's on your phone.
Exactly. Yeah.
Like one of the backgrounds that you.
Sure, she found just a happy one. Yeah.
I
Mhm.
don't know, because I've never even heard that one, or I've never seen the app, but I know people can do that. iMovie, it was always on my iPhone. I just didn't ever click on it.
Yeah. The
So,
frustratingly optimistic, I guess is.
so frustrating for us.
Yeah,
We're gonna be
that's what I
completed.
mean.
Thanks for completing your project on time. Will they get a bonus? They do it.
Oh, yeah, we'll give him a bonus. It was good. It was good to talk. I hadn't texted him in a while. So,
So he would still answer all my questions in the same way, you think, if I texted him?
I think you ought to write down some questions for him and maybe even mail them off and see what happens. See if he'll respond to you. I have no doubt. Don't forget President Holland's talk. That snippet. He seemed like he wants to text you if he could. Yeah, that, it's all true. That's all I can say. They haven't forgotten.
I know they want to work on their project and they're not too happy and busy. You know, that's how I spelled it out. Oh, just like, I'm busy.
Well, true
I'm
for that.
It's good. It's good. You know what I'm saying?
No, he's still very interested. He hasn't like forgotten about us.
I know he has other projects, so I don't know how much time that takes. but
He's involved in this latest batch.
Wow. Remind him when you do text him back that at the beginning of this project, he said there was only like a 3% chance that there would be trouble from certain aspects. And that seems like 100% trouble because that's where it all started. So find out about that.
Right.
See what he has to say for himself on that issue. And you know exactly what I'm talking about.
I do.
Recall what I'm talking about?
Oh, I know exactly what you're talking about.
Okay.
Judge, I'm gonna stop at 16:35. Detective, who is asking who to obtain information in that snippet we just heard?
Lori was asking Chad for information.
Your Honor, I'm gonna continue playing at 16:35.
You may.
So I want to know why that is 100% instead of 3% chance of having a problem.
I think he was somewhat right in that. The other aspect was other people. It was a combination.
No, it was a combination. Not saying there were other problems, obviously. It's of the location. But what I'm saying is that it's a combination of only, 5 problems.
I agree.
That was the big one.
It was a big one. Uh-huh.
So my faith in those kinds of guarantees are lower.
Me too.
And beggars can't be choosers, I get that, but you know what I'm saying?
Mhm.
Thing that I want, he's just gonna have to figure it out.
Right.
Since I'm here and I can't be in charge of the project, so.
Mhm. Yeah. I've thought back on that entire scenario.
We went over the plan and the blueprint.
Mm-hmm.
And
And yeah, he said that wouldn't be a problem.
Well,
What's your take on that? Why was that?
It really was.
Right.
No, I don't doubt that. It's just strange how it blossomed. So
So go ahead.
you go ahead.
No, I'm just gonna say, so. You think it was meant to have complications and? Meant to. Go that direction?
At some point, yeah.
Well, then. You should have said, hey, this is a 99% chance that. We're gonna have trouble with this soil.
Yeah.
Right? I mean, that's all we were asking.
Well,
Could this potentially be good, or do we have to fill it with sand?
I think we sensed that we shouldn't take it lightly, and I don't think we did. I mean, we only discussed the matter with the trouble once, and I thought we cut it off and did well, and now that problem is kind of causing its own trouble for itself.
Right. But there's other things in the project where when I'm going back over it, right, that I could have easily done or been inspired to do to avoid a lot of the issues that are gonna come up with that.
Yeah.
That we weren't made aware of, so. You see what I'm saying?
Mm-hmm. I
So
do.
it was meant to go this way, you think, is what I'm saying.
I do. It's terrible. Minor changes here and there, but overall, this was part of the blueprint. I mean, just
What?
oh, I just wish it hadn't been. But I'm thinking of previous blueprints where the people weren't warned either. It's maddening. Ray's in that contractor position for a reason, and he's not gonna drop us for another project.
Well, can't he like forcibly use a hand, punch some people in the face and get some things done? Some people in particular, like the 3%er person?
I don't think he wants to be violent, but
Well, I'm not saying be violent, I'm saying get their attention.
Me too. what he did is kind of mute her effect. The I don't know, just kind of kept her in her place for quite a while, to the point it almost diffused any value of her.
Not talking about that. In the beginnings, going back over the whole blueprint and all the things that we've been, I don't know what the word is, when you go through it. Anyway, a lot of that stuff could have been avoided.
Yeah.
Just minor tweaks.
Yes.
And I don't know why it had to go down this road to where we are now in the project.
Mm-hmm. I know. I don't fully understand. I think he'd text you back or write you back.
Ultimately, what I need from you is that the project is going to be finished and everything is going to be fine and it's going to work out.
That's what he said.
Well, I need you to tell me that every day, several times.
Okay. My sweet, lovely Lola. Things are going to work out. Not just because he says so, but because I know so. It's a marvelous plan. Slight
How do you know
hiccup.
so?
How do I know? It's been shown to me, honey. I've seen those beautiful eyes filled with tears as she sings to amazing groups of people, and I've seen that wonderful body dance to heavenly songs.
Your Honor, I'm stopping at 2641. Detective, in that conversation, who is asking who for assurances?
Lori was asking Chad, and we found that throughout multiple phone calls. She would ask Chad for assurance.
And who said they had seen the plan?
The defendant, Chad Daybell.
Your Honor, I'm starting again at 2641.
Your purpose is only beginning, it's hardly begun. And it will be the pair. It won't be solo. And it's going to be incredible.
Be cholo and not solo.
That's right. Yep. It will be the Eurythmics. No solo careers. I'm just absolutely sure. I was saying it will be the Eurythmics. It won't be two solo careers.
I know, but I'm saying, you said you have absolute what? Confidence?
Absolute assurity, confidence, confirmation. It's going to be as seen. There's some things that aren't going to be altered. Your value is tremendous, immense. and needed in every way. You're tremendous, my love. I know that is a fact. I think you underestimate yourself. I'm not trying to give you a big head or ego because you don't have one. You just are spectacular, and the Lord is going to use those talents. You're on earth at this time for that purpose. I'll try to call you back so we can pray. Okay.
Your Honor, I have no further questions.
All right. Council, before we begin cross here, I think this would be an appropriate time to take our mid-morning recess. So let's go ahead and do that. It's right at 10 o'clock. So if we could start up again, we'll try for 10:25 to be back with cross-examination starting.
All rise, please.
We're back live. This is actually live. This is not Memorex. Okay, let me gotta find it. I have to shut it off. I think it's kind of funny that I'm almost wearing the same color hoodie I was wearing yesterday. I just looked up and went, oh, I saw me side by side. Oh, so I'm gonna put something up real quick. Nate tweeted this out so that before they come back from the break, I'll show you guys. You guys probably already seen it, but I'll put it up anyway. And put it on. Let's see if it shows up. Let me see. Yeah. So this is the indictment. Where the dates. This is the first part of it. The defendant, Guy Daybell and Noreen Vallow, on or about the no barking. Go. Oh, hold on, my dog is barking. Y'all can read that for 1 second. Sorry about that. I had to get them out. My son had to take care of them. All right. So that's the first part. This is the part in yellow. And then here's the second one. So that's the amendment. So I just wanted to show you those. So that's what they're going to be dealing with when they get back. or they said that prosecution has to argue next because he said that they've had plenty of time to do what they were supposed to do or something to that effect or whatever it was he said. And so now they have to argue it. So they should be back, and since there's no jury, they'll be back sooner. So probably closer to the 2:30 mark. I hate the way I hate it when I have both of these ear things in and I'm talking. I feel like I can hear the inside of my head. Hey, Paula, good to see you. Oh, true crime headed on as breaking news. So what are we looking at? Wait, I missed something. What did I miss? Okay, let's see. So Paula says, I just X might get off on a typo. Is this correct? X who? What is X? What am I missing? Chrissy says she highly doubts it. So let me know what the heck is it. What is, I wouldn't think he'd get off just a new trial. Jen says, I remember reading that whole thing back in 21. This is crazy how long it takes to get to trial. Oh, X. I'm all, who's X? Oh, Twitter. Sorry. Oh, Elon, you have messed me up. You and your X. He'd have to have a mistrial and the state refused to retry the case, and that's not happening. Oh, you're talking about this one. Okay. The X threw me off. I'm all, who's X? Oh, I'm like, are you guys talking about a rapper? I just watched Larry on East Idaho News breaking down the pain in his voice, but yet holding on to hope for justice for innocent JJ. Oh my God, that about tore me up. Make sure that you watch that on East Idaho News. Be sure to tune in. I'm sure that they will either have it up on the YouTube channel or it's right on their website.
Pleaded.
Here we go.
All right, good afternoon. We are back on the record on case CR 2221-1623, State of Idaho versus Guy Daybell. We took a recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an issue with count 4 and permitted additional time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from a case, State versus Taylor, 157 Idaho 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process, and the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof, but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29, starting then with the counts that I am prepared to rule on. On count one, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements, he was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned. That this occurred in the county of Madison, state of Idaho. There were locations testified to by officers Joe Powell, Colin Nesbitt, that the victim Tylee Ryan was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Consitis. Also Chuck Consitis on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Consitis testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses, and the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren, and looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion, and count two, the judgment of acquittal motion is denied. Moving next to count three, conspiracy to commit first-degree murder of J.J. Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count 3. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau, that the overt acts, again, were testified to by witnesses including Zulema Pastenes, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those 7, actually 6 overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count 4, as I mentioned. On count 5, this is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. In that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenes, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count 1, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count 2, Ashlyn Rand and Chuck Consitis testified about the overt act there. Count 3, Nick Edwards. Count 4, Nicole Heidemann. Count 5, Nick Balance. Count 6, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first-degree murder count, as it relates to J.J. Vallow and the issue the court brought up. So, Ms. Beatty, are you prepared to argue that?
I am, Your Honor. Thank you.
I'll hear additional argument on count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Thank you, Your Honor. Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be, because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment. Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count 4 jury instruction, which is very similar to what the court in Jones did, as we'll discuss in a moment. Third and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, the state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to the date within count 4 as to anything about count 4. Under Idaho Code 19-1420, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code section 182403 sub 4 sub A to section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in Overt Act 10 under count 5 from, quote, month, unquote, to, quote, months, unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of J.J. Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, J.J. Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, a date is not an element of a crime. And I know that that sounds counterintuitive where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And an Idaho Supreme Court's case, State versus Jones, dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 19-14-14, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, the true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense, unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial or between the information and the jury instructions only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend or was left open to the risk of double jeopardy, unquote.
I do have a question about variance.
Yes.
Because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29. And I see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal.
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course.
question.
Thank you, Your Honor. So that would be the state's, and I understand that, I certainly understand the complexities that this course of action presents to the state. But there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here. And I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, I think State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there, Ms. Beatty. Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point, after the state has rested, is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now, he pled not, or excuse me, guilty, not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full force and effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge, I think it's 118 Idaho 244 that talks about Idaho Code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction. What it does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
All right. Looking back over a rule here, I have an additional question perhaps from Ms. Beatty. I'm looking at Criminal Rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument, but you may.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor is citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake not within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge, they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment. They made the allegations. They're stuck with their indictment.
All right, counsel, let me take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling. All right.
Okay. Waiting for them. Okay, so what I'm going to do is I am, for those of us who have trouble, I have trouble following it, but let's see. I'm going to go back and read the updates like I do. You know me. And I'll even also show the amazing stuff. We're going to look at what I'll do is I'll share this and we'll look at it this way. Let me get that bigger. Should be able to see. All right. And then I will take that away. So, I mean, I think we'll have enough time to kind of look at it all. We're okay. Through the directed verdict. Back in the courtroom. I'm trying to build let's see where I want to start from, but so basically Beatty lists out the evidence that states presented in relation to each charge. She mentioned, okay, let's see. We're back in the courtroom now. Argue for directed verdict. Ruling from the judge after determining there is no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. Pryor says there is no indication that Chad was present in the murders of JJ or Tylee. So that was before. This was all the stuff that happened before. So 12:30. So it was 2:30. Let me go back to 2:30. So these are the things that I put up earlier. This is the indictment. I mean the amendments. So this is the original right there. And then that's the second that they're discussing. So there, we'll start it here. So back in the courtroom, here's a look. I showed you that. Judge Boyce is on the bench. Pryor is sitting next to Chad. Yada, yada, blah, blah, blah. Okay. So Boyce has prepared a ruling on everything except count 4, which is a first-degree murder for JJ Vallow. Boyce says on count 1, state has presented significant evidence, so Pryor's motion is denied. Count 2, Boyce says state has presented significant evidence, so Pryor's motion is denied. Count 3, same thing, denied. And this is on the motion for acquittal, denied. Count 5, motion for acquittal, denied. Count 6, denied, count in the final count, and denied. So then Ingrid now argue count 4. This is the part that's probably confusing to everyone. She says the state has 3 options. 1, because count 4 did not fall within scope of the court's December 8th, 2023 order to amend, the court can simply correct it so it conforms with what count 4 should be. Second, the court could accept there is a variance and instruct the jury that there is a variance. Beatty said court could also add an item in the jury instruction. Third, the court could reopen the case to allow the state to correct the indictment and formally amend it. Beatty argues her first option says state made a motion to amend the indictment in November 2023 in 3 ways: modify subsection in count 1 and 3, modify language in count 2, 3, 5, and modify language, quote, month to months. Nowhere in state motion did the state ever seek leave to amend any portion of count 4. Beatty says, so Boyce approved the motion and it was amended. Beatty says when the motion was filed, the date of JJ's death date was inadvertently changed on count 4. Beatty says there was indictment for 2.5 years that had the correct date and all parties were aware of it. This is the key. This is what's going to get Pryor. He's not going to win this. She says it was a clerical error and the court should utilize Idaho rules to let jurors know it was amended. He says the second option is for Boyce to accept there is a variance with indictment date and instruct the jury that there is a variance. Beatty says this is a variance in dates, while in other cases there have been variances in years, and it hasn't been a problem in those trials. Boyce asks Beatty about variance. He says variance typically comes when one jury instructions don't match the charging documents. Quote, what the state would be requesting is we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging documents. You're suggesting I permit a variance to essentially cure the issue, Boyce says. He is not aware of any other cases where a court proactively grants a variance. Ooh, okay. Beatty says this was a clerical issue and the court can reopen the case to address the issue. The state would then amend the indictment before resting to get it in compliance. The state could then rest again. Oh, I get it. Quote, we are all falling on our sword here. This was clearly an oversight. I think it should have been oversight. We are talking about a clerical error in a subsequent document that was not in the original document, Beatty says. Beatty finishes her argument. Pryor now arguing. He says, the authority to reopen a case almost exclusively applies to evidence, not amending a complaint. He says he didn't object to the original motion to amend. Quote, from that time forward, that's the information I relied on. Any change after the state has rested is going to create a substantial due process argument for Mr. Daybell. He does make a point. He does make a point. Oh boy, what is the judge going to do? Pryor cites a rule that says the court can allow an amendment before the state rests, but not after. Pryor says the state doesn't have any right to ask for a variant or amendment at this point in the trial. Quote, they have to make any amendment and correction prior to resting their case. Pryor says. He says 4 lawyers have had over a year to analyze this, and after they rest their case, the court correct it. Pryor says he wasn't going to tip the court off. There was a problem. Ooh, what? Pryor asks Boyce to dismiss the charge. Pryor says Idaho Rule 7 says prosecutors cannot change the indictment after they rest. They, quote, they don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue, Pryor says. Beatty responds by saying there is a process for making amendment. Quote, we are asking the court to correct what is clearly a clerical mistake, she says. And now we sit here and we wait for the judge, because I think, let's see, was there any, let me make sure, double check and make sure that, so 301 was where that ended. Let me go out and make sure that I've got it all before I stop, because I am now wondering, what will the judge do? Because after rereading it, I'm thinking, yeah, there it is. All right. Nope. Oh, no, it just, of course it did. Of course it did. Every time I do this, it always does that. It takes it away. Then I got to do it again. Go back in. Try it again. Oh, fudge. So 12:45. No, we need the rest of it, please. Oh. Yeah, it's not giving it. Sometimes this thing drives me crazy. It's the only part I don't like about this on these dates, is it does not give you. I should do this without y'all having to look at it. Let me put this back up. Hold on real quick. That way you're not looking at it flash. Sorry. Here, we'll put that. Now let me try to do this again. Oh my goodness. Come on, thing. This might be it. Let's see. Did that do it? Nope. Okay. Anyway, I'm thinking that, what do you guys think that he should, first off, what do you think he should do? Should he just amend the jury instructions, give them something and say this thing happened, put it through? What is the legal thing? Do you believe that Pryor is correct in this, and should it be the way he's saying it? Or should it be something that does not, or should they allow prosecution to reopen the case, fix that issue, and then rest again? What does that cause? I mean, what does this cause? What does it harm? This might be it. I might be able to see it now. Yep, I got it. That's good. All right. So, 301. Okay, so 302. Boyce asked Beatty to clarify about how the issue happened. Okay, so this might help. It was when the amendments were approved on the other counts, and the date on count 4 somehow got changed. She says it was a clerical error. Pryor says the jurors read the indictment. It was published, and the mistake hasn't been caught until now. But didn't he just say he saw it and he didn't want to point it out to the court? Didn't he just say that? If he said that and now he's arguing this, he held that and said nothing when he saw it, so that he can argue this. This is what he's trying to do. He held off before he let them close, knowing that it's an issue. Isn't that what I'm getting? Are you getting the same thing? They should not be allowed to change it. Boyce says he needs to take a recess before he rules. We'll be back and ready for him to rule. Okay, so I went ahead and just read the rest of that. So do you think? I think that is exactly what I heard. He knew, he saw it. He should have stopped right there, and he should have called a sidebar, and it should have been handled then. But no, what did he do? He let it go. He let them rest, and he called it up. Now, is it wrong to do it this way? I don't know. I kind of hope that that's kind of called out a little bit. Kind of thinking. My whole thought process changed now that I read the rest of that he saw it and said, "Ha ha! I found my ace in my ace in the sleeve, whatever the heck that term is. I don't do well with those, but whatever." Oh, so sorry, I got all excited over that one because I was like, wait a second. So he absolutely, well, as a layperson, not in the legal sense and all the stuff with all the lawyers and stuff, but as a person watching a trial, that irritates the crap out of me. I feel like he played that. Now, is it wrong for him to do that? If it were wrong, I think judge would reprimand him for it. So we'll have to see what happens when the judge comes back and if he even brings that up. But I think that it is a strategy that is used by attorneys in situations like this. They see something, they let them go through and do their thing, and then they turn around and they use it in their case, because as soon as the state rests, then there's a whole space where they have the directed verdict portion after the state rests, and that's when they can take that stuff up and try to use that. Now it's the judge's job to look at the prosecution and say, y'all should have known and made sure, even though they keep saying it's a clerical error. Yes, but you have to cross all your T's and dot all your I's. I hate those. I can whatever, but they should have done that, and this is on them. But do we want the court? Do we want the judge to stop everything because now we run into due process issues? I think it is, but you know what? If it's allowable and it's not something that like, okay, so Nika says underhanded. So what I'm saying, well, I'm responding to that. So if it's something that the court doesn't admonish defense for, then as a defense attorney, I'm looking for every loophole I can find, and I'm not going to point anything out that will tip off the prosecution if my job is to save my client from the death penalty. And that, in my opinion, is what he is thinking in this. That's his job. His job is to save him from the death penalty. Sorry, I am worked up over this one. This was a good one. Now it's going to be interesting to find out how Judge Boyce decides to rule on this. Yes, he admitted he knew. And I don't know if that if the judge doesn't say anything to him, then it's something that is not an issue for a lawyer to do. It's sneaky for us who are watching, and it probably doesn't feel that great. But I think that is what is that's my opinion. Wait, I gotta put something up. I always forget. It's that thing. So that's what I think I'm seeing, and what do we not want to happen? Let's start there. As a trial watcher, not even thinking with a legal mind or whatever, but as a trial watcher, what do we not want to happen? First off, we don't want a directed verdict. We do not want to have to start this thing all over again. The whole thing over again? Isn't that what a directed verdict would do? Or is that judgment for acquittal? Directed verdict. Here, let me look at it. I have to look it up again. I have to get it in my head. Define verdict. Okay, so again, so put this in the chat real quick so that at least I can see it. I have to see it. I'm glad you guys put up with me doing this stuff. Here, let me get this in. Okay, so directed verdict is a ruling by a trial judge that a jury doesn't have enough evidence to reach a different conclusion. The judge usually makes this ruling after the plaintiff has presented their evidence. But this isn't about the directed verdict. It just hit me. This is about, sorry, ignore that. Forget that. This is not about the directed verdict. This is about count 4. I think what Pryor wants, thank you for letting me work through this in my head. But I think that, let me just, we don't need that. Okay. I think what Pryor wants them to throw out count 4, right? So that they don't even have to worry about it at all, because he says there's been no evidence that connects him to JJ's murder. So he therefore now wants to get rid of count 4 altogether. So he's not charged with that. I don't think that that is what the judge is going to allow to happen. If the judge allows prosecution to reopen the case, fix what needs to be fixed, and then rest again, it will move on that way. I possibly feel like that's what the judge is going to do. I thought maybe he would just make a thing to the jury and say there was an amendment, and he'd give them a instruction that would go with them to the jury deliberation room, that would be a part of their instructions. But they've already seen the indictment. Yes, count 4 is JJ Vallow murder. Yes, and Pryor is trying to get it thrown out, if I'm saying it right. Let me see what you guys are saying. Are you guys sorry? Oh wait, I'll get rid of that one. Delete. Yeah, because it just hit me. It's not about the directed verdict. We dealt with that. They're dealing with this as a separate issue. I got all wound up in directed verdict. I always get really to looking at those and go, yeah, it's not, the judge is going to say no, but this is different. This is a completely different matter. This is trying to get rid of a count, and especially a count that means so much to the family, to the victims in this case. Larry was just on camera with, was it Hidden True Crime and Nate, and he's crying over this. He's crying over what this, let me get me, he's crying over this. This judge knows, I don't think judge is going to allow this to happen. I think that he is going to fix this the best way it needs to be fixed so that the count remains. If they have to open it up, fix, and then re-rest, then I can kind of see maybe that's what they have to do. What were the other options she had? She had quite a few options. He does have options, but what's he going to do? So her first option, she says it made a motion to amend indictment. So I'd sound like there's so many of these things that he doesn't really want to do. So can he amend what do you guys think? Like, what would be the best option? Let me read and see what you guys are saying. Sorry. Yes. I'm kind of looking at some of the stuff you guys are saying. So we got Nika thinks it's underhanded. I think that I'm not a fan that it happened as a trial watcher. He admitted he knew. Yes, he admitted he knew. And Brian thinks that the judge will throw out count 4. I hope not, for the sake of the family. JJ is the biggest part of this case. He's one of the biggest parts of this case. It would be devastating. So is Linda still here? Linda, are you keeping an eye on seeing if Nate has said anything? He probably hasn't said anything since the last thing that she put in the chat. It's still, and this is this is accurate. That's what I'm saying. Like, for us as a trial watcher, of course, we're like, yeah, that's sneaky. Yeah, okay. But he should be able to do this. If he sees something, he can use that. He doesn't have to tip him off. He doesn't have to. Because he can use that after they rest, like he's doing now. He's doing it properly. It just stinks. It stinks to see it. And it stinks to know that this is hurting Larry and the family. This is a horrible thought. And now they're sitting on pins and needles. And this is all over. Yep, it's over a clerical error. That's why you have to make sure. Judge is right. Prosecution had time to make sure this didn't happen before they rested. I said that they have been doing a fantastic job with all of their testimony, and I mean, with all the questioning and all the stuff in this case. But this one, I hope that this gets handled the proper way. Oh my goodness. Sorry, I was griping at my dogs. Not griping at them. I was actually saying my dogs are barking all the dang time. They're driving me crazy. Sorry about that. So, oh, I did that one. Yeah, I can erase that one too. Ignore. Okay. So I don't think that he's actually going, because he lost. I don't think that this will be a mistrial, because I was thinking of something else. I was lost up in the acquittal or the directed verdict thing. So all this is what's going on now is the fight of count 4. Keep count 4 or get rid of count 4. Let the prosecution open their case, fix what needs to be fixed, and rest. That's where we're standing. And there are other things that that were put, or that was it Beatty stated that could happen. But I'm trying to decide what we think the judge will do. We don't know. I have no idea. So Nika says, well, then take the death penalty off the table. Oh, okay. Was that even an option? It wouldn't be a mistrial. It would be dismissal. Yes. See, you guys. Okay. So where I'm at in the comments right now is where I was when I'm sitting here saying, oh, wait a second. I kept the directed verdict and this count 4 thing together when it was 2 separate issues. First he had that, and then they argued this part. I combined them in my head. I do that often. I have to talk my way through it. So thank you for putting up with me. Deborah says, does anyone remember why they took DP off for Lori? It was something stupid, I remember. I'm sure somebody's. Let me see. So the death penalty was removed for her as a sanction for late disclosure of discovery. The judge said deciding on Daybell's culpability before trial would impact the jury and predetermine facts about the case. Daybell's second motion argued. Oh wait, no wait. Oh, this was what is this? Wait, is this it? Wait. Oh, that's not it. That's not it. What? No, it is it. The penalty was removed. Death penalty still an option. Oh, okay. There. Yes. Sorry. So that it was removed for her as a sanction for late disclosure of discovery. So then copy. And late disclosure of discovery is when a party fails to return, sequester, or destroy information that is subject to a claim of privilege or trial preparation material. The party must also not use or disclose the information until the claim is resolved. More or less. So essentially, a party must disclose to the other parties the information, documents, and witnesses that support the party's claims and defenses. Discovery refers to the procedure by which each party learns about the information, documents, and witnesses that the other party does not have to disclose. And so then that it was the penalty was removed as for her as a sanction for late disclosure of discovery. Okay, did that help any? So there you go. So now so there was an issue with her on that. Do you think that they're going to do that? Do you think that that's what they're going to do in this case? Do you think they're going to remove the death penalty to solve this problem? I don't know. I think the count 4 needs to stay. And prosecution needs to fight to keep it. It's just horrible for them. I can't imagine the grief they must be feeling. Yes, the family. So if he lets it go, if he gets rid of count 4, is that what you're saying? Is that let it go? If he lets it go, wait. Let's see. Yeah. So count for JJ. Yes, Deborah. Toby says, I kind of want to go back and get. So I'm at the start of the day. I can't imagine what happens later. What are we seeing above? Oh, just remember sometimes when I'm really going on here and I'm looking at stuff, I'm not looking at the chat. So I may not see you guys trying to get my attention or anything. I'm up in looking at stuff, trying to figure, like come up with stuff. So Brian, which part leaves the appeal wide open? If he lets it go, that is a reason for an appeal. You mean count 4? And then Brian says we're in each other's brains. Dana says, I hope he doesn't, but I'm feeling judge will dismiss count 1. That's what I thought. Yes. So I am on the same. I don't want him to let it go. No, I don't. Of course I don't. I mean, count 4 is a doozy. That would be no justice for JJ, right? So that's where. So it will be a travesty justice for the, yes. That's where my brain is. Well, this is a real turn of events. Absolutely. Celine, it's very sad, but it's grounds for an appeal. So if it's left in, Linda or Jen, if it's left in and left as is and amended or whatever he does, that's what the grounds of appeal is, because the judge allows prosecution to go back and do it and then re-rest or whatever it is. Or is that what you're saying? This fell into Pryor's lap and he wants to pretend he noticed it. Oh, you think that's what it was? He says that he saw it and didn't say anything. Well, I saw it. So they will have to retry him on count 4. So does that mean that they would go along, they would do the trial on all of those counts and then have to have a separate trial for count 4? If it's thrown out, is that what you're saying? Mal, from what I don't know, I'm sure you know already, but Larry was with Hidden True Crime. Is her name Lauren? And Nate, and he was crying. I haven't seen it yet. It's up on their I think it's on East Hyde. It's already up on their thing. So Nika says make a deal. So this is why you have law clerks go over everything. I'm thinking of the Woodcocks having to go through this all over again. Yes. And that is why. But if they don't remove the count, does that mean that it opens it wide up for appeals? Is that what you're saying? And Mal says, I think Boyce has a loophole up his sleeve. Dana says, unless Beatty's, oh, we're back.
Thank you. Please be seated. All right, we're back on the record on CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4 after noting that the dates of count 4, in fact, were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue, as well as the defense. And the courts considered those arguments, and at this time will make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on criminal rule 29, which is for a judgment of acquittal. I already indicated the standard and the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court, having considered the arguments of the state and the defense, I'm going to rule as follows as it relates to count 4. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case May 25th of 2021. An amended indictment, which has governed this trial, was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024 where the governing charging document was the initial indictment filed in this case. The state, by motion in November of 2023, sought to amend the indictment, and the court went back and reviewed that motion to amend the indictment, and specifically leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023, granting permission to amend the indictment. Among the charges sought to be amended, count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of JJ Vallow of honor between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. Going back to count 4 of the amended indictment, if I were to disregard the dates in there, the court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Guy Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreaux and Garth Warren, among others, about this alleged count of first-degree murder involving J.J. Vallow as a victim. And he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of J.J. Vallow in this case, lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court, having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I have also seen case law cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It was not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that. But for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beatty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
All right.
Oh, helps to actually turn myself on. Sorry. And trying to keep those. I have to remember to look when we do these motions and stuff. Now, I want you guys to know this is the first trial that I have sat and watched every bit and tried to be present in one trial where before I was handling up to 7, and so others were putting information in and I was dropping it in the chat. This time I'm doing this myself, so I'm trying to make sure that with these motions and stuff that I'm trying to absorb it. And when they put a lot of stuff together, like we got the first part and then the second part with the count, and it was kind of all accumulated or whatever put together, I'm like, oh, so basically, let me see what you guys are saying before I say anything. Just rip the Band-Aid off. Okay, I scrolled way back, so we're going to do this for a minute, and I'm not going anywhere. I want to talk through this with you guys before we end for the day. And then Candy says, spit it out. Say it. Say it. I see everybody. Spit it out. Nika says, don't drink. I don't drink. I don't drink. You might want to. I mean, there's some wine. Wine is okay. My blood pressure. Dana says, right, Pryor set in on Lori's trial. Oh, that's right. Okay, yes, he sat in on the trial. So the alleged dates match Lori's. Okay. Inadvertent mistake. So we obviously heard it right there. I was waiting. Yeah. I was hoping to get it up on the screen so that it kind of matched with what was being said. Because remember, there's a delay between you guys when you guys get it from Linda and when I actually hear it on my end. So I hope that what I was putting in was matching with what they were actually saying, or in a roundabout way, because I don't think he was. Nate doesn't do word for word. So I was trying to match it the best I could. So, Jen says that, well, and then she says, frankly, I'm shocked. So we're moving on with trial. Things are staying. He's going. What was someone put in chat what the final thing was he said? Because now so it was acquitted. I mean, it was denied. Nothing's changing. They don't have to go back and open up their case, fix it, and do it. They're just going to do what? Because now I'm confused. Case moves forward. So yes, the case moved forward. So did Linda let me go back and see. Did you put this in? Where is it? I'm not seeing Linda's posts. Did I miss them? Did Linda put them in? Oh, I don't see them. So I'm going to reread it. I'm sorry, guys, because now I don't understand. I know it was denied. The motion was denied, but what are they going to do? So Boyce finds there has been sufficient evidence in the elements alleged in count 4. He denies the motion for acquittal. As for the dates, because count 4 was changed without permission, he finds it was an inadvertent mistake. Quote, while these jurors have already heard the information contained in the amended indictment, the court believes the jurors can be fairly and properly instructed. So that's what he's going to do. He's going to add to the instructions, which is what I thought was going to happen, that he was going to add it to the instructions and then just keep going. Because I know that some think that it's grounds for appeals later. Stuff happens like this all the time. You amend it, that there are provisions for it. The judge knows the best thing to do. And if I miss you when you left because I'm yammering on, I'll see you tomorrow. But I had to get that settled in my mind before I let this go. So wait, did he say no court tomorrow? He did he say that? Hold on. Did he say that? I see it. Wait. Brian says there's no court tomorrow. So wait a second. He wasn't. I think he has to look at something else further. Okay, let me refresh this and see if there was more added to that. I'm not seeing anything. Oh, well, whatever. I mean, if I keep, hold on, let me get to the bottom of this. What will I do? Wait. Dang it. Monday, judge will decide whether to say something to jurors, but adding to instruction whether to let the state reopen. Okay, there we go. Okay, so no court tomorrow. Okay, no court tomorrow. I was still trying to figure out my whole brain was trying to figure this out. Sorry about that. Okay, so no court tomorrow. We got it. We all work together in this. Okay, well, then tomorrow's a day off. Tomorrow is my full fun Friday. Yay. So you guys, thanks for hanging out with me. Thanks for putting up with me. Thanks for all the things. Thank you for all the help. Linda, thank you for posting the tweets. Thank you everybody for working together to get the info in where it needs to be. Sometimes it takes a lot of hands, and I'm thankful for everybody who's here. And thank you for your support. Please like, subscribe, share. And if you would like to support me further, you can do this little thing that I'm going to put in now. And right here, this would rock if you would like to do this. Oh, well, don't oin. It should be join. Here, let me do that, not oin. There you go. For some reason, Linda and I do the same thing. We tend to leave the first letter off because we don't look before we post. I do it all the time. I'm glad I'm not the only one. So I want to see this again. So Boyce, just so we get it, Boyce says he raised the issue, not the defense. Boyce says he needs additional time, thank you, as to how to exactly fix the date problem, but he denies Pryor's request to dismiss the charge. Then we'll be in recess until Monday. Thank you. Thank you. In trying to figure all that out and go back, there's part, actually, when I kept refreshing, right? Yes, it's not giving me that. I don't know where unless that's a tweet from Nate. Oh, it's right there. Well, dang it. Because that's why I didn't see it. I don't even know if it was put in the chat. I was trying to find it. Thank you. Thank you, Jen, for catching that, because I could not find it. And I still have no idea if Linda put it in the chat. Sorry. Oh, my goodness. Okay. I feel that the end of this video was an utter fail. Okay. Well, then I guess I will see you guys Monday. And have fun. I don't think I know of anything that's going on. Any of the people that I talked about earlier, if they are doing anything, go give them some love. Tell them you came from me. And I will see you guys bright and early Monday morning. Bye.